I was looking for it.
First case for argument is 718, People versus Liberatory.
Good morning.
Good morning.
Good morning, Justices. This is Charles Greenberg for Tyler Liberatory as he's appealing from his conviction to a violation of probation and from rendered in Ontario County. The people appear to agree with point 1 concerning the waiver of the right to an appeal, so I'd like to go directly to point 2. Do you have any questions before I address my one concern with point 2? Okay, my concern with point 2 is that when he entered the colloquy, he basically was just asked a question, a series of closed-ended questions where he was all he basically said was yes, 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 pretty much for the entire colloquy until he got to the end, and then he just says, I admit. But based on that, Your Honors, I would submit that kind of colloquy doesn't really come to what's required. He doesn't really explain to the court as to what he did to violate the probation. All he just was basically just a recitation of yeses. So my argument there should be yes.
Has he preserved this issue?
Well,
Preservation, I mean.
he did not vacate it. There was no formal vacatur or motion to vacate it.
So the issue is not preserved.
Well, but it can be. You can still address it either as under People versus Lopez, or you could address it under the
Interest of justice.
on the interest of justice jurisdiction. But it's not formally preserved. No, there was never a motion in Ontario County.
For us to address it under Lopez, your client would have had to have said something that negated one element or called into question his guilt. He did neither.
Well, but only does it say is yes. I mean, what exactly does that mean, though? So that's why the argument is that he doesn't really deny it, but he doesn't really affirm it either. So,
I think we have your argument.
thank you.
Thank you.
Good morning, may it please the court. Chris Eagleson in response for the people. We will rest on our papers, but happy to answer any questions the court may have.
Thank you.
Thank you.
Case number 720, People versus David Smith.
People will rest on it.
Thank you. Case 721, People versus Saunders. Good morning.
Good morning, Your Honors. May it please the Court, Christy Cooper of Counsel Thomas Iwanu for Mr. Saunders. This appeal stems from the conviction of Mr. Saunders after trial by jury for criminal sex act in the first degree, strangulation, rape, and predatory sexual assault. But missing from what the jury heard was evidence that the trial court themselves called, quote, absolutely critical.
You're going to have to speak up just a little more.
Yeah,
I apologize. Again, missing from what the jury heard was evidence that the trial court themselves called absolutely critical. In this case, the victim, Miss Heather Kelly, was known to have been diagnosed with bipolar disorder, a disorder that had a long medical history noted throughout the record.
Is there any indication anywhere that somebody with bipolar disorder is less credible?
Your Honor, I
Because that's
believe,
really what, it sounds like you're suggesting that the defense lawyer should have called an expert to come in to say this affects somebody's credibility. How do we even know that there is such an expert who would say that?
yes, Your Honor, when the court called that piece of evidence absolutely critical, they were speaking about the observations made by Nurse Olay of Miss Kelly immediately after the incident. She described
Didn't
Miss
she
Kelly
say
as
that
having...
her interaction with that victim, this is victim number one, lasted about, what, 40 seconds?
I believe it was a minute, but yes, it was brief. And I think that the reason that there was so much of a record created was that it was somewhat of a checklist. So her observations were able to be recorded rather quickly. But in that observation, she said that there was evidence of delusional or paranoid thought content. She also said that Miss Kelly was making threats to real or imagined objects. The evidence of this could have been expounded upon by an expert to state that bipolar disorder, as characterized by manic episodes and depressive episodes, can include, in a manic episode, delusional thoughts, paranoid thoughts.
I guess my
something
point is,
that would...
for all you know and all I know, the lawyer did seek, did try to find some expert, and maybe wasn't able to find one who was willing to testify to that, as far as we know.
Your Honor,
This isn't an obvious point that somebody who has mental illness is less credible than somebody without mental illness. So you don't know, maybe the lawyer did try to find a witness.
Your Honor, I believe throughout the record that there was discussion by defense counsel that he could potentially call Dr. Coe, who was Miss Kelly's long-term psychiatrist, and that was not done. There are other psychiatrists, and it's well established that the mental health profession has a guideline of mental health diseases.
So, counsel,
Yes, Your Honor.
this is a case where the victim was calling for help. A police officer came to her aid while this, in the middle of this act, so to speak, okay? And she had rocks and stones in her hair, and you want to put an expert on to say that the acts were consensual and that she's a little bit mentally ill, and therefore we might believe at some point that these acts were consensual? Is that what you're trying to tell us?
Not necessarily that the acts were consensual,
Well,
but
that
that she was potentially experiencing a manic episode, which is
And it
characterized
wasn't really
by...
happening?
Well, if, Your Honor, if I could direct you to Mr. Saunders' initial statement, where he said that the act was consensual and that both had fallen asleep. She was awoken by something, potentially the presence of a police officer nearby, and then became agitated, then began to call for help. So that is different than her continually being conscious and stating that this was not consensual the entire time.
You wanted to impeach her credibility based on her mental capacity, and whatever. And your thought was it was somewhat less than it would be for others, given her history, right? And also given her behavior that evening, understandable as it might be. But wasn't the issue that you didn't get access to a lot of her records?
There was some preclusion of access, however.
But that's
and
not an
defense-
issue on appeal.
The predominant issue is that an expert was not called to discuss the potential that her credibility was at issue
But
at
if
the time.
My
of
point
her
being, I
allegations.
think, if the expert had nothing upon which to base his or her opinion, based on the records that were denied to you, and now the issue about records having been denied apparently is not before us, so how can we even get to that ineffectiveness argument, saying that you didn't call an expert who couldn't have testified anyways because he or she didn't have the records? That's the problem I see.
Your Honor, from the record, the judge agreed to review those medical records in camera without disclosing them to defense counsel or the prosecution, I believe, at
And
the
he
time.
did that, right? The court did that.
I believe that there were some of them reviewed, and the judge did then essentially urge defense counsel to get an expert to explain bipolar disorder and to explain the effect of a manic episode on someone's
Right, but look, I
credibility.
thought that your client's defense was that victim 1, who allegedly had bipolar disorder, was in cahoots with victim 2, who was raped 10 months later. Victim 2 being related to the defendant, and there was a custody situation. That was the theory of the defense, that victim 1 made up this rape, lied to help victim 2 with her custody battle. Do I have that right? That's what the strategy was?
It was a part of the defense, but the defense was that the encounter was consensual with Miss Kelly.
Right, so the victim, Miss Kelly, in cahoots with victim 2, says, okay, I'm going to engage in consensual relations with this man who I haven't seen since high school. Then I'm going to claim rape, all to help somebody I don't really know win her custody battle. And that seems to make no sense whatsoever. Makes even less sense when you consider the fact that victim 1, Miss Kelly, when the police came, she didn't want to file any charges. She just wanted to go home to her kids. If she was involved in some conspiracy to falsely accuse a guy, you would have thought she would be cooperative with the police so as to effectuate their plan of falsely claiming. None of it makes any sense whatsoever.
My understanding is that the claim that they were in collusion, or that they colluded to make these allegations against Mr. Saunders, was also in the second allegation that came from Ms. Abisher. So the custody became an issue at that later time, not necessarily only at the time of Ms. Kelly's allegations. However, I believe the credibility of Ms. Kelly was not fully explored, and that in itself could have been substantial error because there was no expert, even at the urging of the judge, the trial court, to provide an expert to explain the effects of that disorder on her credibility.
You're getting very close on your time, and I know that you have a number of other points in your brief, so.
I would say, Your Honor, I would also note that Nurse Olay was not called, in addition to an expert not being called. Nurse Olay being the one that observed her hours after the event. And defense counsel noted that it's possible for someone to act even potentially irrational immediately after in a traumatic event, if that is what occurred, but that for hours later, when this observation occurred, that behavior was continued.
Again,
A hallmark
they
of a
brought
man.
her in and they met with her, and she indicated she had only was in her presence for 40 seconds.
Yes, Your Honor, I believe that was the intensity of the
So
manic,
But they
potentially
may
manic
not have called her
episode.
because she wouldn't have given any testimony favorable to the defendant.
I'm sorry, could you?
They may not, the defense counsel may not have called her because she would not have offered anything favorable to the defendant. It may have been there may have been a valid strategic reason not to call her.
To call Nurse Olay? I think
Yes.
that without calling Nurse Olay and without calling an expert, we've now ventured into the territory of a
Ineffective
substantial error.
Okay, thank you.
Thank you, Your Honors.
Good morning, Your Honors. May it please the court, my name is Laura Jordan on behalf of the Niagara County District Attorney's Office. This defendant here received effective assistance of counsel. There was overwhelming evidence in this case that defense counsel was making an attempt to fight against. He did so, he advocated for his client, and the evidence just quite frankly was too overwhelming in this case. As far as the bipolar disorder, there was no link or connection between that disorder and her ability to perceive the events or would show that there would be an effect on her credibility. And there was no evidence to show that she was having a manic episode at the time the incident took place. So this defense counsel doesn't have to pursue claims that they don't think will be fruitful at a trial, and I submit that this counsel simply did not do that here.
Would you agree as a general rule that when you have claims on appeal that a trial lawyer should have taken steps that weren't taken, or should have done this, should have done that? We've had 2 of those cases already this morning, that the more proper context is a 440 motion?
In this case, yes. I mean, there's a number of points here. I guess we don't know whether or not they went to pursue finding an expert on bipolar disorder and whether there just wasn't one that would back up what the defendant's claim was here. The same thing with defendant's other argument about explaining things during the plea consideration. There's a number
Most
of
of these alleged errors are not evident, if they are errors, are not evident from the record.
Exactly, Your
And we
Honor.
have said, the Court of Appeals has said that in most of these ineffective assistance of counsel cases, they should be resolved. The better form is a motion rather than direct appeal.
Yes, Your Honor. Any further questions? I'll rest my brief. Thank you.
722, People versus Wright.
Good morning, Your Honors, and may it please the court, Jeremy Schwartz for Roderick Wright. Insofar as the lower court's decision relies on the odor of marijuana to support the search of the vehicle in Cheektowaga in which the gun was found, it should be rejected. Was no testimony that I shouldn't say there was no testimony. The officer originally testified that he smelled marijuana coming from the defendant and the vehicle, or from the direction of the vehicle. But what I hope is very clear from the brief is that the officer clarified that he can't say that there was an odor of marijuana from the vehicle.
No, so his testimony was, as I read it, the odor was coming, the defendant had just stepped out of the vehicle, it was left the vehicle, and the odor of marijuana was coming from that vicinity. So it was coming from, I think he said it was coming from the defendant and the vehicle, the area of the vehicle. So he didn't know if it was coming from the defendant or the vehicle, or both.
On direct examination, he did say the defendant and the vehicle, but he clearly said he cannot say whether it was coming from the vehicle. His only interaction was with the defendant, not the car at all. He arrested him immediately, took him about, I believe...
Well, all right, so he detained him. I know you say that this was an arrest, but...
Well, he said he
forced... I think the people say this was, and I think the court found this was a level 3 encounter, not a level 4 arrest.
I think that was error as well.
I know you do.
The officer's testimony was that he forcefully handcuffed the defendant and put him in the back of the police car. That was before any firearm was found. Now, doing that, regardless of the level of what the officer thought the level was, objectively, any person that is not otherwise guilty of wrongdoing is going to think that they are under arrest at that time. The officer asked him where he was going. He kept walking, as was his right to do, and the officer...
The officer at that point had knowledge that he may be armed.
So that's why
So
the
when he
jury,
walked away, it's, the question is whether he had the right to make kind of this forcible detention.
so the officer would perhaps have had the right to approach him, pat him down for firearms. He found marijuana on the defendant, which also obviously could explain the odor, but did not find a firearm. The firearm was found in the vehicle by some other officer that didn't testify.
But before he encountered the defendant, the reason that he stopped him is he had this information from a complainant ahead of time of a person who matched the description of the defendant, who was in possession of a gun.
He did not say possession of the gun.
Right.
The individual,
He had threatened him with a gun, he'd used the handle on the other side of a door to knock, he didn't see the gun.
the complainant's statement was that he had heard a slide rack of a gun or that could be the gun. Now,
And didn't he say that the person on the other side of the door threatened to kill him?
he said the person on the side of the door threatened to kill him.
And then he heard the racking, it sounded like the racking of a gun.
That's what the information the officer had. So what that brings us to is whether the officer even had jurisdiction to do that. If we get past, it does dovetail with the marijuana issue, because if the officer didn't have jurisdiction to believe that he had a gun at the time, or even the possibility, then it would have given rise to issues with the vehicle as well. But that does make it very similar, and I'm going back to the car search here, to the car search in Pistori, which in that case there was an actual description of a gun. The defendant in Pistori actually said he owned a gun, and the defendant in Pistori even admitted that he had in fact threatened the person. The car was searched, and this court found, this was just a couple years ago, that search there was no probable cause to search the car for a gun based on that information. Now that's why there's a jurisdictional issue here too, because let's just say the complainant in this case did a sworn statement and said everything that he said to that officer in a sworn statement, that somebody said he's going to kill him, it was from the other side of the door, he heard a slide rack. If that was written in a statement, that would be sufficient for a harassment charge. It would not.
Possibly CPW, somebody says they're gonna kill you and then they hear the racking sound of a gun. I understand your point, but it's arguably a crime as well.
If he said he saw a gun, yes, an individual who can say he saw a gun, first of all he could say is what appears to be a gun, because
It sounded like a gun.
or what sounded like, again, that could even be a fake gun. So he doesn't even know, even if he is an expert to the level of, or familiar with guns to the extent that he can tell that it's an actual gun based on that sound, he still wouldn't know whether it's a real gun, a BB gun.
No, but when the officer stops this person who matches the description of the defendant, is in the location identified by the complainant, and who's got information that there may be a gun, isn't he entitled to detain the person to see if it is a real or a fake gun?
He is entitled to pat him down to search for weapons, and perhaps the odor of marijuana.
Except that he wouldn't stop.
No, so let's just say that he was allowed to grab him. He's allowed to ask him to stop, maybe pat him down. Maybe the officer did need to put handcuffs on him in order to pat him down. But before he put him in the back of the police car, he knew that he did not have a gun on him. So the question is whether, under Pistori and other cases, would another officer been allowed to search the car? And without the odor of marijuana, absolutely not. I think even with the odor of marijuana, because of the jurisdictional defect, they would not have been able to, because they were out of their jurisdiction, and the odor of marijuana, this is case law that probably we'll never have to get to because of the law change, but there's not really any on it, an out-of-jurisdiction officer doing a marijuana-based search. But the problem with that is that the odor of marijuana is equally indicative of a violation level marijuana. It could be half an ounce or even close to an ounce, and they would be outside of their jurisdiction, not able to arrest somebody for that. So I don't think the court.
You could search a car under our old case law. If there's an odor of marijuana coming from a vehicle, you can search a car. But now we have the new laws, which you don't argue are retroactive?
I'm not. I think they've been found to be not retroactive, Justice Lindley. So I'm not making that argument, but I am making the argument that A Lancaster officer in Cheektowaga, even in 2019, would not have been allowed to search a car to determine if there's marijuana in it, because that's just as likely, and probably more likely, a marijuana violation. And they can't search for violations outside of their jurisdiction because they could not arrest for violations. What would he have done? So unless the court has any further questions?
Thank you.
Thank you.
Good morning. May it please the court, Jerry Marti for the people. In addressing the first point that was raised by defense counsel, there was a distinction in the questioning between the source of the marijuana odor and the source of the marijuana. The police officer did not need to know where exactly the marijuana was. He needed to have probable cause to believe that it came from the vehicle, and he testified multiple times that the odor came not only from the defendant, but from the vehicle itself. Second, in addressing that second point, which dovetails into the tip, there was reasonable cause for the officer to go outside his jurisdiction. I'd like just to point out that the reliability of the complainant is presumed here. The police officers had an opportunity to speak with this informant. In terms of the tip itself, defense counsel notes in his brief and again in his argument that the gun wasn't seen. The court here is free to consider that not only that what the complainant saw, but also what they perceived as the fact asserted. This is brought out by the concurring opinion in the Court of Appeals case of People versus Argus, page 1164. Here, there's a distinct sound made by the racking of the slide of the gun. This sound was loud enough to go through a closed door. This sound is very distinct and will get your attention, as brought out by a second department case in 2001, People versus Forbes. In that case, when that sound was heard, two police officers instantly and simultaneously looked up. Based on the reliability of the tip and the basis in the informant's knowledge, coupled with the confirmatory observations as brought out by the court, it was not only that the defendant fit the description, but also the vehicle matched the description exactly. Color, make, model, out-of-state license plates, and the close proximity in distance and time all together provided reasonable cause for the officer to make the arrest based on a suspicion of a crime. Unless there's any other further questions.
Thank you.
Thank you.
723, Inner Harbor Phase versus Core Inner Harbor Company, LLC.
Ask the court, would you like to hear
Mr. Kerwin.
Good morning. Terry Kerwin on behalf of the proposed interveners. Unless there are questions, I'll rest on the papers submitted on that issue.
Okay,
Thank
thank you.
Good morning. May it please the court, Christopher Bucky on behalf of the defendants. Unless there are questions with respect to the court's decision on the intervention motion, I'd be happy to address the denial or partial denial of the motion to dismiss. And with respect to that motion, I think what's clear from the briefs is the plaintiff would have this court believe that this case is about some elaborate fraudulent scheme, but there really can be no fraud here because the plaintiff admits that all of its loan proceeds, every last dollar, were properly used for the development and construction of the hotel that is the subject of this loan. Plaintiff was fully aware that its borrower, which is Core Inner Harbor, did not own this property, yet plaintiff required its borrower to put all of the loan proceeds into the development and construction of this hotel. Plaintiff could have done a number of things. It could have required a security. It could have required guarantees. It could have required an agreement with the owner of the hotel property, which is Core West Kirkpatrick Street.
At the time, was it still the city of Syracuse that owned it at the time of the loan?
As of September 2012, when this process started, Your Honor, the city owned the property. It transferred it to Core West Kirkpatrick Street in May of 2014, roughly 2 months before the closing.
When was the money advanced?
The money was advanced after that on it was advanced on July 15th, 2014. It was actually dispersed in September of 2014. So what the record shows.
So the money was advanced, sorry, I didn't catch the dates well enough. The money was advanced when the city of Syracuse still owned the property?
No, that's incorrect, Your Honor.
When Core West Kirkpatrick owned the property?
That's right.
All right.
It's actually helpful to understand, at least briefly, the timeline here. This process started in September of 2012. And at the very beginning, when the application was submitted for the loan, the plaintiff was told in no uncertain terms, you're not getting security for your loan. And then 6 months later, because this was a 2-year due diligence, 6 months later, in March of 2013, plaintiff again asked for a second mortgage lien in connection with the loan. It's told no, flatly rejected. And then, as Justice Curran pointed out, a year later, the property is transferred from the city of Syracuse to Core West Kirkpatrick Street. So at that point, the plaintiff has at least constructive notice.
The property was transferred in May of 14, and the money was put into escrow in July of 14.
That's correct. So on July 15, 2014, 2 months after the property is transferred, Core Inner Harbor signs the loan documents. Loan documents prepared by plaintiff and its counsel. 3 days later, while the loan documents and the money are all in escrow, plaintiff receives an insurance certificate that shows Core West Kirkpatrick Street owns the property. Not Core Inner Harbor, Core West Kirkpatrick Street. And then on the same day, it also receives an email informing it that Core Inner Harbor, the borrower, does not own the hotel property, and in fact owns no property whatsoever. But the thing is, it gets worse for the plaintiff because at that point, it still could have revisited all of its loan terms. Or it could have just pulled the plug on the loan completely because it had until September of 2018 or 2014 when it authorized disbursement of the funds. So it had a 2-month window to revisit this with this full knowledge that its borrower didn't own this property.
Right, counsel, I think I don't disagree with anything you've said. Plaintiff had knowledge of that Core Kirkpatrick was going to be owning it. Plaintiff had knowledge that they had no security interest in the project. Plaintiff had knowledge of all these facts you're talking about, but what the plaintiff says is what we didn't know was going to happen is that the borrower, Core Inner Harbor, was going to take the money we lent to them, millions of dollars, and transfer it to a sister LLC controlled by the same folks who controlled the borrower, was going to transfer all that money, $4 million, and receive no consideration in return. That's what they say they were unaware of. And that's not an unreasonable expectation. I mean, it's when you lend somebody money, you don't expect they're just going to give it away, especially that kind of money, without receiving something of value in return, like a partial interest in the hotel. That's what they claim they didn't know was going to happen, and that's the basis of their debtor-creditor claim, is that the borrower took the money, gave it to somebody else, and was thereby rendered insolvent. They say you can't do that under the D&C law.
So there's a couple of things, Your Honor, with that. First, plaintiff is elevating form over substance completely, because again, Core Inner Harbor did what plaintiff expected it to do and did what plaintiff required it to do. Every last dollar went into the development and construction of that hotel. If plaintiff wanted an agreement with respect to, some consideration coming back from the beneficiary of the loan proceeds, it should have required it. The plaintiff controlled this whole loan process. It controlled the loan documents, and it was fully informed of all the facts. And if it wasn't fully informed, that's on plaintiff too, because it had a 2-year due diligence and had the ability to learn all this information. But look at it this way, Your Honor. If Core Inner Harbor simply paid all of the vendors directly.
Right, I understand. You made that point very well in your
Yeah.
brief, that if they just paid expenses, legitimate expenses, that's totally proper. But which company would pay expenses for a project that they don't own? Under your scenario, your question, Inner Harbor is going to pay millions of dollars to contractors for materials and labor for the hotel project. When Inner Harbor has no interest in that, they're paying somebody else's bills. That's not the normal course of events in a construction contest.
It isn't, but it was fully apparent to the plaintiff, and the plaintiff blessed this structure. The plaintiff understood exactly
Let me
how the
interject on-
structure.
I'm sorry to inject.
Yeah.
I'm looking at the escrow letter.
Yes.
And that's really sort of, to me, one of the linchpins to the fraud claim. That is, we're going to deposit this money, says the plaintiff, and we're going to give it to your lawyer. And your lawyer is going to hold an escrow, and it'll be distributed in this manner. And the only distributee will be CORE, not Kirkpatrick. And somehow, some would say that it smells a little fishy that all of a sudden all this money is going to Kirkpatrick, not to CORE. So, I mean, the lawyer may have a problem, but putting that aside, I mean, doesn't that reflect on the fraud that what was promised by your client vis-a-vis their lawyer didn't occur?
Respectfully, no, Your Honor, because the problem is, and this is where the plaintiff's claim has to fail in terms of fraud or breach of contract or anything else. The plaintiff admits every last dollar went into the project. So there was no improper use of the money. Just because the money wasn't paid directly from the borrower to the vendors and instead went to Core West Kirkpatrick Street first and then was properly dispersed, that doesn't create a fraud claim.
When you say admits, and I'm sorry I don't have it at my fingertips, what portion of the record do you rely upon to say, if you can point it out to me, it doesn't have to be specific, just generally, of where you say the plaintiff admits, to use your word, that they knew that every single penny went into the project?
If you look at, I think I actually got to look at plaintiff's brief. They do not dispute. Let's just take
different than admitting, sir.
Let's just take a step back, Your Honor, because the key here is a year before this action was commenced, CORE gives the entire loan project file to plaintiff's counsel and says, go ahead and take a look. This is what's going on. Had all the project financials, and plaintiff was able to see where all the money went. And so plaintiff.
Are you saying it's a tacit admission?
No, I think I'd like to try to find where it's an actual admission in the record. I think there's a reference in Mr. Eckert's affidavit, which is towards the end of the record, where he acknowledges that the loan proceeds were properly used. And further, Mr. Eckert acknowledged that they were aware of different entities during the course of this process, and they ended up contracting only with Core Inner Harbor. And that's what the problem is. In effect, plaintiff isn't saying, we thought we were contracting with Core West Kirkpatrick Street. Plaintiff admits or it acknowledges that it was only contracting with Core Inner Harbor.
Can we agree on that point? Can we agree that Core Inner Harbor has no defense to the breach of the promissory note to the plaintiff?
Yes, that is correct.
That's obvious. They didn't pay it back. So then the only way the plaintiff can recover is if the corporate veil is pierced, correct? If it's pierced. You say it should not be pierced.
It cannot be pierced, but
Okay.
yes.
So plaintiff has a rock-solid cause of action against Core International for the full amount of the unpaid loan. Would you agree that, with the allegation, that there's common ownership and control of Core Inner Harbor and Core Kirkpatrick?
No, Your Honor, and that's not sufficiently alleged in the complaint. The problem is...
What's the difference in ownership? Some of the principles are the same. Would you give me that much?
I'm not aware, and there's nothing in the record that indicates who the different principles are. There is just one single generic allegation in the complaint that says, with respect to control, and all it says is upon information and belief. There are no specific allegations with respect to complete domination.
Is Stephen Aiello an owner of both?
I don't think it's in the record, and no, Mr. Aiello
Well,
is
no,
not.
this was a 3211 motion, so really what we're looking at is whether it was adequately pled.
And
And your point is or your argument is that it was not, but, and you say there are inadequate specifics, but some of that information may be in sole possession of the defendants.
But it's not, because we turned over the project file to the plaintiff before the plaintiff commenced this action. So if there was any evidence to warrant corporate veil piercing, or quite frankly, fraudulent conveyance claims, the plaintiff would have used it to support its complaint, but it didn't. And it does matter about the allegations with respect to veil piercing. Both this court and every other department has made it clear. You have to specifically allege, and just so we're clear, the plaintiff hasn't alleged who controlled the two entities. Plaintiff hasn't alleged that any of the members were acting in individual as opposed to corporate capacity, and plaintiff hasn't alleged that any of the individual members receives any of these loan proceeds. And it can't allege that because, again, the proof that was given to plaintiff showed every last dollar went into the project. None of it went to the individual members. There was no profit taken here.
And Counsel, just so I quickly looked at Mr. Eckert's affidavit, and I'm looking at page 896 just for the reference, and he says, it is unknown how Core West Kirkpatrick Street Company, LLC, accounted for the $4 million in their books and records.
And that's simply incorrect, Your Honor, because the
It may be incorrect, but it's not an admission.
Okay, I understand, but if we want to characterize it as there's no dispute in plaintiff's brief that the funds were properly used, I think plaintiff's words were that's immaterial whether or not that the funds were properly used. And in the record, we put in detailed record in Ms. Johnson's, detailed evidence in Ms. Johnson's affidavit and Mr. Mannion's affidavit, the attorney who was involved with this project, to show that all those records were provided to plaintiff before it commenced this suit. And with respect to the law firm, Your Honor, I would say, first of all, the claim that's asserted against the law firm is not, you can't tell if it's either a breach of contract or a tort claim, and that's fatal to it. But more importantly, if we assume there was some sort of breach of the escrow agreement, again, and we've
If we
cited...
assume, well, it seems fairly evident that the escrow agreement said, this is how much money should be paid to which parties and when, and it wasn't followed that way.
But as we pointed, it's no different than a closing, a regular mortgage closing. If you distribute the mortgage proceeds, they don't all have to go to the borrower. At a closing, you will cut checks to pay the various people who are owed money, to pay off the prior mortgage, to pay the taxes. You don't have to run it through the individual borrower and have the borrower write the check. So what the law firm did was consistent with a practice in connection with the closing and properly dispersed the funds.
It clearly did not send the money to Core, the law firm.
A portion of the money was sent to Inner Harbor, but at the request, because there was a closing coming up for the acquisition of the property.
But to Justice Lindley's point, if you just look strictly at the language of the escrow agreement, there was a breach, correct?
I disagree, Your Honor. I think it's elevating form over substance, because as long as the funds were properly used, and let's assume there was a breach, the plaintiff cannot show any damage because, again, all of the funds were properly used to fund the development and construction of the hotel.
Anything further?
Unless there are any further questions, we'll rest on our brief.
Thank you.
Thank you.
$725, Dabalski versus the Courtright Family Irrevocable Trust.
Morning, Your Honors. Oh, I'm sorry. Morning, Your Honors. Tom Gaffney from Lippis Mathias on behalf of the appellants. I'll get through my points fairly quickly. It's fairly straightforward. This lawsuit was brought to challenge the Third Amendment to a trust. And in that trust is an interim clause that says that if you challenge any of the parts of this trust, including amendments, then you lose all your rights and you cannot pursue it. So we moved to dismiss on that basis. That's part of it. That's point number one. In response to that clear and unequivocal provision in the trust, they cite case law that says it must be strictly construed. I don't dispute that it needs to be strictly construed, but they don't then cite any facts that say that once you strictly construe it in the circumstance, it is invalid here. They simply don't cite anything, nor any case law.
What if Joanne amended the trust agreement to give money to herself? Be clearly improper. Would you agree under Joanne, who's one of the trustees, under the trust agreement, can't give money to herself?
I think if there's self-dealing, perhaps it elevates. I haven't looked at the case law, but it would be different.
If Joanne were to give money to herself or a neighbor or a friend at work, and then Christy Lee or some other beneficiary were to challenge it, you're saying that the courthouse doors would be shut to such a claim?
I'm not, Your Honor. What I'm saying is, in this circumstance, there aren't such facts where it sort of smells bad or it looks like self-dealing or things we don't have that here. And therefore, even if you strictly construe it, it's still valid. In that circumstance, perhaps the strict, construing might have a different result.
So we look to the merits of the transfer to see whether the forfeiture clause would apply?
I don't think so, but I think, Your Honor, what I'm suggesting is the case law makes clear you need to strictly construe it. Strictly construing, in my understanding, is you look at the surrounding circumstances and you're sort of suspect about the situation, but it doesn't mean it's invalid. And they haven't pointed to any of these suspicious things like self-dealing.
But isn't your opponent says, well, we're not saying that the clause is invalid. We're seeking to enforce section 3.06. That's what this action is about.
But that's inaccurate, because what they're trying to do is toss out an amendment. They are challenging an amendment.
But if an amendment's invalid, if it's impermissible, then they're just trying to they're seeking to enforce the last valid trust agreement.
That's not entirely.
What Justice Peredato is getting to.
Well, but if you look at the cases they cite, the Bowler case that they cite, that really supports that position that, look, there's a distinction between challenging something and trying to enforce it. In that case, there's a provision that said, in circumstance X, dollars need to be paid to this person. The trustee failed to do it. They sued to say, hey, trustee, you need to pay that. I'm trying to enforce that provision, affirmatively getting them to do something. And the court said, that doesn't invoke the interim because you're not challenging anything, you're simply enforcing the language. But here, they're saying the Third Amendment was invalid, and it needs to be disregarded.
Let's assume that we get beyond that, you lose on that, and we get to the merits. Whether this was a valid amendment. What are your views on that?
So there's two.
Your argument seems to be that because Christy Lee is a linear descendant, her share can be diminished at will.
No question about that. In fact, they don't even address that point.
And that's what happened here.
That's correct.
She went from the residual beneficiary, which probably would have had a lot more money, down to $100,000. And so we just focus on Christy alone, Christy Lee, and it doesn't matter what happens to Christy Lee's money. We can bring in the brothers who aren't descendants. We can give it to other people. She doesn't have any standing to really challenge. It's permissible to reduce her share, and she has no standing to contest who her share goes to, even though the people who her share goes to, which is Joanne's brothers and sisters, should not be entitled to any distributions here. That's what you're saying.
Yes, I mean, it's sort of slightly separated out from that. Point 2 in our brief is that there is no question that Joanne had the power to move Christy, who is a lineal descendant, which is their only argument under 306 that the other part is invalid, but that she could go from residuary to $100,000. They don't argue that was improper. They just try and glom it together with the third point in my brief. But generally, Your Honor, that is what I'm saying, that once she is reduced to that, she's not affected by any other change that is made.
Somebody else, would you agree that the brothers, Joanne brothers, it was improper to amend the trust agreement to give them distributions? They weren't linear descendants? Joanne has no linear descendants whatsoever. So her brothers and sisters, would you give me that much?
I would give you that these brothers that were brought in are not lineal descendants. And if we focus only on 3.06, the section that they rely on, that yes. But that isn't to say that there is something else. That it was just not focused on because our argument was there's no standing. But I will give you that those two individuals are not lineal descendants.
Well, and the brothers, I think there were 4 of them that came in.
I thought there was only 3, but perhaps that's right.
Okay, but whatever. Her siblings should not, she had no authority to give her siblings money under this trust agreement. And you're just saying Christy Lee has no standing to challenge that obvious improper grant of funds.
Yes, I think that the third point is focused more on the switch of Judith to become the residuary, which is a little bit different than what Your Honor is talking about, which is adding those two other individuals. I mean, we essentially argued standing on that, and nobody really got into the merits. Under the 3.06, though, for purposes of today, Your Honor, I guess I would concede that if it's literally limited to that section. But we think it's far more important that the language says, with respect to making Judith the residuary beneficiary. She was an existing beneficiary at the time. She was not then added. And the section specifically says, in addition to the previous powers and notwithstanding any other provision to the contrary, Joanne can switch the residuary beneficiary. That's what happened here. Their argument is the provision above doesn't allow it. And then they say, oh, he's not, giving meaning to all language.
Yeah, they say
He has no way of addressing the section that I just quoted.
They say
Notwithstanding.
Judith is locked in at 25,000 and it can't ever be changed because she's not a linear descendant.
I'm sorry?
They say Judith is locked in at the 25,000 because she's not a descendant and she can't be increased and she can't be decreased.
That's the position they've taken. Based on the 3.06, that limits it to lineal descendants. But the language of the section that I'm quoting and relying on talks about current folks and residuary beneficiaries. And it also says, notwithstanding anything else, we're allowed to do this. So to me, I mean, their interpretation, in my view, ignores a large portion of 3.06. So I'll rest on everything else on that, but thank you very much for your time, Judge.
Thank you.
May it please the court, Frank Jacobson from Ralph Larigo's office on behalf of this respondent, Christy Dybalski. This is just a classic case. Husband has a second wife. They go through estate planning. This is a large trust agreement. A lot of thought obviously goes into these types of agreements. And there's then nearly a decade where they abide by the agreement. There are 2 amendments during that time where they abide specifically by the agreement, only affecting lineal descendants. During that nearly decade of time between the execution and the death of the husband, you have providing in the trust that we're going to get the income, we're taken care of, and then it's going to go about 95% or more, approximately, to the lineal descendants. Then, surprise, surprise, he passes away, and then the second wife, I'm going to give everything to my family instead, and you guys are all out, all the grandchildren are out, all the great-grandchildren are out. Pardon?
He didn't say everything. Chrissy Lee still got 100,000.
Christy Lee, she is the daughter, correct. She goes from residuary, but all the grandchildren out, all the great-grandchildren out, and everything goes over all of a sudden miraculously to the Browns, okay? Now, there are only 2 provisions that are really applicable in this case, I think, that are relevant. 10.03, which has the interim clause. They're highly disfavored in any context, especially in estate planning. They're also to be strictly construed. The appellants claim that I haven't talked with that our papers don't talk about how it's strictly construed. It talks about amendments. Number one, there's always going to be the question, can you in advance prohibit an objection to something that's going to happen in the future? An amendment that hasn't even been created.
Mr. Jacob, typically those clauses, as I recall from circuit court work, is that they're there primarily to say you can't contest a testamentary capacity or undue influence. If you go after the entire arrangement, you've tried to avoid it ab initio, then you can't. That's not what you're doing here.
Correct. And in that document, so you're talking about it being in a will, that you can't challenge this, but would it apply if you change the will in the future and you leave out an interim clause? Because that's exactly the situation here. They're trying to say, we say you can't challenge this or any amendments, but those amendments, as in this case, wind up going completely contrary to what the trust says. The strictly construing it is this an amendment? They're called the First through Fourth Amendments, but they're not really amending anything. They are simply exercising that limited power of appointment. So there is no amendment. There's an exercise under 3.06 of a power of appointment, completely different than an amendment, okay? So that's the strict construction. even if there was an amendment, again, it's completely contrary to the plain language to give this to the Browns and Ms., the actual trustee here, Ms. Varga, who was that fourth person, I believe. She's a sister instead of a brother. But the interim clause does not apply to an invalid exercise of a limited power of appointment, and it doesn't apply to enforcing the agreement. I mean, she's simply seeking to enforce through this action the plain language in there. And of course, the lower court has essentially found that there may be an ambiguity. Do I think there's an ambiguity? No. Does he think that there's an ambiguity? No. But we're reaching two conclusions as to what this section 3.06 is, and essentially, although the lower court didn't say ambiguity, that's essentially what the court wound up saying in all but words is, you say this, he says this, question of fact, let's go on to discovery. The appellants next argue about 3.06, allowing it to be an unlimited right to change anything, mere sentences away from the very provision that says, no, lineal descendants only. It renders it meaningless. That's completely contrary to this court, the Court of Appeals, well-established construction of contract rules that you can't just leave provisions with no meaning. The meaning of the first provision is clearly that it has to be lineal descendants. Sections 2 and 3, or the second and third paragraphs, then go on to talk about, again, still lineal descendants, and then the fourth paragraph, he says, ignore all of that, we can do whatever the heck we want. Well, here's the problem. Completely contrary to this being an irrevocable trust, which, again, not only 3.06, but 1.03, this is irrevocable. Once you can name yourself, so if it's unlimited, those settlers the court rights, could have named themselves. That makes it revocable. Because they can just name themselves beneficiaries, and that's that, the trust is over with. There's an irrevocable trust, it's in the trust provision, it's in the name. The interesting thing is the name is the court right irrevocable trust. Apparently they want to make it the Brown irrevocable trust, even though none of them are in the family. 3.06, as I said, I think it is pretty plain. That first paragraph talks about who can be a beneficiary. Those are lineal descendants. It talks about adding, subtracting, and naming new beneficiaries. The last one doesn't talk about really changing amounts. It says you can change these things, but, this is the fourth paragraph, but if you do, you can change them, and you do it in this manner. You can do it in the manner of a written amendment or a written directive to the trustee, or you can do it in your will. It's really a how it gets done, not who, and that's the only valid way to look at this. There is an argument that is in the appellant's brief that they had the right to the power to decrease Ms. Dybalski's share, and therefore, like, she has no standing. I didn't address it because it wasn't really raised until their brief. But that being said, she has the power to decrease it. But then you have to look at Article 5. What does the rest of the trust agreement says? It says that if there's something that doesn't vest, it's going to go to Ms. Dybalski. That's what it says. She is the under Article 5, she recovers as the sole lineal descendant of the soul of the first order. So she's a lineal descendant, first order, she's the daughter. She's going to recover under Article 5 if anything doesn't vest. So that's simply not the case that we don't have standing. We certainly get it essentially under our reading, and even under their reading, if nothing vests in those brothers and siblings, she gets it as well. That being said, that Third Amendment is clearly void. The lower court properly denied the motion to dismiss,
and therefore this court should affirm the same. Thank you.
Thank you. 726, Grace versus Cayuga Youth Athletic Association. Good morning.
Good morning. May it please the court. James Special for Cayuga. Plaintiff here assumed the risk of getting hit by a bat at a baseball game
Okay,
for...
so let me stop you there. Did he assume the risk of getting hit with a baseball bat anywhere on the premises? In the parking lot? Or in the playing field? Or in places designated for people to be swinging bats? What did he actually consent to?
Okay, so here's the thing with that. He doesn't have to foresee the precise manner which it happens.
I
No,
agree.
but,
Yeah, go ahead.
but when you talk about primary assumption of the risk, you're talking about assuming the risks of those things that are inherent in the sport or known to the participant. This participant was 9 years old. So I think the argument is that this accident happened in an area that was not a normal area for a person to be swinging a bat. So that seems to be the question. Is that a risk that's not inherent in the sport?
I think it is, because to me it reminds me of if a ball goes in a concession stand, right? Which you can still assume the risk. Or if it gets hit on a field next to you, you still could. He's still right next to.
Let's change the facts a little bit. Let's,
Okay.
just using your example.
Okay.
Let's assume there's a designated area where foul balls can land. That's it. All right?
Yeah.
So similar here, there's a designated area for on-deck players. It's fenced in. It's fenced in for a reason, right? To protect others from the person swinging the bat. And this particular individual was outside that fenced-in on-deck place, as I understand it, swinging a bat where everyone seems to agree he probably shouldn't have been. Now, you're looking, Mr. Special, for summary judgment as a matter of law on assumption of risk. Don't you think there's some questions of fact there, given the fact that there's a place for the on-deck batter to swing the bat that's protected?
I don't because where he is on the field, to me, see, when Your Honor says about a foul ball, I mean, he's basically right in the same place where a foul ball
I was
could
using a
go.
weird example, which is the best I can come up with
Yeah,
at the
no.
spur of the moment. But my point is, when there's a designated area for the activity to occur, and it's outside that designated area, then doesn't that at least raise a question of fact about when the batter is outside the designated area, assume whether or not the plaintiff assumed that risk of that person being outside the designated area where that's where they're supposed to swing the bats, not here, but there.
Okay, so let me change your facts slightly different. Okay.
I thought I finally got to the facts of the case.
Yeah. So let's say he's playing hockey, and the player is wearing skates in a locker room where you probably shouldn't, right?
We have that case.
Yeah. Right.
Yeah.
So
So,
your foul ball analogy doesn't seem to fit, and that foul balls by definition can go anywhere. They get sprayed in the parking lot, in the street, into the stands. But swinging a bat, practice swinging, isn't so random. And if, for example, I can even, if we had a batter out in the bullpen working on his swing, bullpen being where pitchers are warming up, not a usual place to be swinging bats, would you say that that's an assumption of risk for someone swinging a bat? Justice Bannister talked about in the parking lot. Some kid is off in the parking lot working on his swing. Not an on-deck batter, not even behind the fence, not even on the field, just working on his swing in between innings in the parking lot. Those two venues wouldn't take it out of the assumption of risk in your view?
Well, I do think there's a limit if it's too far removed, right? I mean, I wouldn't think a bat was going to hit me now.
So where would you draw the line between the designated area for on-deck batters and anywhere else?
I mean, this is still part of the field. It's where foul balls would go.
So is your argument based on the fact that this is a risk that's inherent in the sport, or is it a risk that was known or should have been apparent to the 9-year-old plaintiff?
I think I could say both.
Well, certainly, you'd have a good argument if this happened in the designated area,
Yeah.
because there's a designated area for a reason, and if he walks in there when people are practicing their swing, then that's something he should know or should be apparent to him. But if it's outside the designated area, I don't know how you argue that this is a risk that, of which he was aware or should have been aware.
And that's particularly in light of the fact that there appeared to be a league rule that was communicated by the coaches to the players that they were not to be swinging bats in this particular area where the plaintiff got hit. You have that label to it too.
Right, so I would say two things there. One, there's the hockey skate thing. I mean, you shouldn't be wearing skates in a locker room, right? Two, much of plaintiff's argument is how we seem to conceal the risk or enhance it. So I think that's a bit strange. They kind of try to find some daylight there where it's, okay, well, you told him not to do this minor did. This all happened very briefly. It's like seconds.
Happened fast.
But we somehow increase the risk. I mean, it's the exact opposite. I think we did everything we could so it wouldn't happen.
I think the argument is more that this is an unassumed risk. I don't know that the risk is increased, but it's an unassumed risk.
I would say at some point he would have been too far removed if it was, but I mean, this was on the field, the larger field, if not right in between the baselines.
So I think, I assume, so your point is that even if there's a designated area, people are swinging bats everywhere all the time, and that's part of the sport, and...
Yeah, this also could have happened if the bat flew out of Chucky's hands. It wouldn't have flown in a designated area. Yeah, then, and...
But that's a different situation.
Yeah, it's more like the foul ball. Less control.
I mean, I wouldn't say I would compare this to that, because while it might seem like there's less control, I mean, his plaintiff's own father said no other instructions could have been given. Safety was drilled into the players' heads. This is his father, who was the third base coach, which actually where plaintiff was, because he was on first base, so if you're on the third base, you're looking right at it.
That might go to the evaluation of liability on the part of the defendant in the first instance and comparative fault, but I don't know that those facts are terribly relevant to a primary assumption of the risk argument.
Well, I mean, I see the point, but I don't know if there's less control over something like a foul ball than what happened here, because this was extremely brief, because plaintiff is walking back. He turns back to his grandfather. They talk for seconds. He turns around, he takes like a step and then gets hit. He didn't see Chucky swing a bat when he walked back.
All of that might reduce your liability, but it doesn't negate it under assumption of the risk, right? Those arguments all go to reducing your liability.
Well, so the reason I'm saying that is to show why I don't think there's less control over a foul ball, as Justice Winslow said. This is
You say this is equally inherent to the sport.
yeah, and this is basically a young kid who does something unpredictable. There's nothing else we could have done. I don't see it, so I don't think we hid the risk or enhanced it in any way. I think we did everything we could to prevent things like this from happening, and he's still on the playing surface where the game was being played, so you're gonna have bats swinging, you're gonna have balls.
A lot of these arguments you're making, am I correct that if we affirm the denial of the defendant's motion for summary judgment, if we affirm the denial of your motion for summary judgment, you can still pursue this defense at trial, right?
Well, I mean, yes,
And you
but
can make all these arguments, and you still might be able to prevail if you lose this appeal ultimately.
well,
Correct?
And Mr. Special, you say was on the playing field when he was hit by the bat?
the
That's not what I see in the photo here with the X marked by defense counsel during the deposition.
the larger by that
The playing field, we know what the playing field is, and this is not in the playing field.
right as opposed to like the parking lot or something of it. That's what I was trying to differentiate. He's like right next to where the game is going on. It's not.
So the baseball field itself, not the playing.
Yeah.
I think we have your argument.
Okay.
Thank you.
Thank you.
Morning, Your Honors. Please the court, John Collins for plaintiff respondent Matthew Grace.
Mr. Collins, if I understand it correctly, sir, you fundamentally believe that there are triable questions of fact, right?
That is correct, Your Honor. There are tribal questions of fact as to both whether there was an assumption of risk, and I think there are many factors that would militate against such a factual finding, and certainly more strongly militate against the finding as a matter of law. Because, this, as the court has already recognized and alluded to, occurred in an area where the players were expressly directed, do not go there to swing a bat.
All of that results in triable questions of fact from your position, right?
That's right. And above that, there's a question of fact as to whether there was negligent supervision, and this court has held in cases such as Havens versus Kling that even where there might be an assumption of risk that was assumed of a certain element or hazard, an infant plaintiff can still recover if there was negligent supervision. And here there is certainly proof in the record from the
Not enough that they were instructed not to do it, they needed to enforce the rule.
Exactly. They had to pay attention to what these 9, 10-year-olds were doing, where they were going, and a jury could readily find that that did not occur, and that's the only reason this young boy was out there swinging a bat where he shouldn't have. For that reason, I think the order should be affirmed. Thank you.
Thank you. Case 727, Miller versus the State of New York.
Good morning, Your Honors. May it please the court. My name's Tim Bellavita, the attorney for the claimant appellant. And this is our appeal from the grant of summary judgment in the underlying case involving a New York State
Counselor,
plow truck.
for my benefit, would you focus on whether or not there's a question of fact pertaining to whether the driver was on his run, or whatever the language of it.
Yes.
I needed to really focus on that in terms of what the proof was in support of the summary judgment motion, if any. And I'm almost asking you to put the devil's advocate hat on and say, okay, what's their best shot, if you can see one, in terms of whether they carried the burden to show that he was on his run?
Justice Kern, I think there's several points, and in terms of the issue of, was he actually engaged in work? And the factors have been laid out by this court in numerous cases. Was he actually on his route? Well, that's not my burden of proof. That's the burden of proof of the state.
Well, both of those would be the burden, right? Whether he's actually engaged in work on a highway, and if he's, and part of that is, was he on his run, as Judge Curran was
Yeah,
asking
as I
about.
see it, Justice Perodato, it's all part of, one of the elements of, are you actually engaged in work? Were you on your route? And in this
Did the
case...
driver actually say in his deposition or in an affidavit, I was on my run, this is on my run, this is where I go when I do plow this particular route, anything
He
like
was
that?
asked to describe his route, even better than that.
Did he say that at all? Is it anywhere in the
Not that
record?
I read. All I saw was he described it as Route 390, down to the canal and back up and around.
Right, but Justice Kern's question is the question, I looked at the record today, is I wanted to know, was he asked, were you on your beat or route, I think they called it the beat, when this accident occurred? He was never even asked that. He was asked to describe his route. Now, in the excerpts that you submitted in opposition, which they can't rely on, because they have the burden, but in the excerpts of the driver, the truck testified that his route was the downtown beat. It's the A beat. It goes from Route 390 at the canal all the way around the loop, all the way around the ramps of 390 down through. Doesn't say anything about 490.
Does not.
Doesn't say anything about Chestnut.
Does not.
Doesn't say anything about Monroe Avenue.
Does not. That's correct.
And so your point is that's not sufficient. But even if it were, this is the evidence you submitted in opposition. The testimony that the state submitted in support of their motion is much briefer. It covers 4 pages of his deposition testimony. And that is very brief on any details. You don't get much out of that whatsoever. So you feel that they didn't even meet their initial burden, so they don't even get to the testimony you submitted. But either way, there's no categorical statement, I was on my beat when the accident occurred. The route he discussed does not specifically include where the accident occurred.
That's correct.
So you should prevail on that issue.
On that issue alone.
Even if you lose on salting, and even if you lose on the plow being down, you still...
I completely agree. There's no evidence in this case that was where the accident occurred was part of the driver's route. They never submitted any evidence to that effect.
At trial, the evidence could be different, we suppose, but your point, as I understand it, is on this record, they didn't meet their burden.
At the summary judgment stage, absolutely, Your Honor. And in addition to that, if you'd like to hear on the other issues, I'm happy to talk about them, but there was some issue determination done at the trial
on
court
the
level.
salt, whether they could actually see it or not. We understand your point.
Correct, and that,
Credibility.
any other questions on that, Your Honors? Thank you, Your Honors.
Thank you.
May it please the court, Sean Mix on behalf of Respondent, State of New
You
York.
probably know where we're focusing.
Yeah, and I'd like to address that, Your Honor. Here, Mr. Mobilio was actually engaged in work on a highway because at the time of the accident, he was on his assigned route.
What portion of the record establishes that, or at least...
So on page 134 of the record, claimant's attorney asked Mr. Mobilio, was it your intention prior to the accident to go 490 west?
Can I just stop you there? Was that deposition testimony you said he now supplied, provided by the state in support of their motion?
Well, Your Honor, I know it's in the record.
I know
here.
it's in the record, too. I think it was provided by the plaintiff in opposition.
Yes, it's a part of the Ramsey affidavit. But nevertheless,
But don't you, as isn't the initial burden on the movement to establish as a matter of law that he was on his beat at the time of the accident? And you're not citing me any evidence that you submitted in support of the state's motion. You're referring to evidence submitted in response by the plaintiff.
Your Honor, we're referring to the portion of the deposition testimony that was before the Court of Claims in that.
No, but the point is, we don't even look at your opponent's papers. If you don't meet your burden in the first place, I mean, you know what the law is. We don't even have to look at the opposing papers. Your burden in the first place is to show that you're entitled to the benefit of the statute. That means he's plowing on his route and he's engaged in work on a highway.
Okay, well, to that, he did describe his beat as starting from 390 at the canal, going
Again,
through
that
the...
was in the opposition papers.
Okay. And then I also know that Mr. Mobilio testified that he was actively salting the roads at the time of the accident. And this, although that claimant's testimony and her son state that they did not notice any salt.
We're still on the beat and the route.
Well, Mr. Mix, you must sound terribly hyper-technical, et cetera, but really, it's all consistent with the idea that summary judgment is a drastic remedy. It's not in any cases, but one paraphrase I've used is as though you're at trial and you go first and you have to disprove every element, in fact, on the other case. But you didn't see it in your motion papers, at least I didn't.
Oh, Your Honor, let me just turn here.
I think Judge Martin relied in part on the fact that a state trooper initially responded, and therefore...
That's true. The state trooper did respond, and the state trooper did say that this took place on the I-490 on-ramp. And so therefore, this was part of Mr. Mobilio's assigned route.
So at worst, you're saying because a state trooper responded and because he said he was salting, that must mean he was on his route?
Yes, he was on a state road. He was actively salting the roads, and therefore he was on his assigned route.
But the state trooper, if I'm not mistaken, stopped his investigation after he arrived, and it was referred to another law enforcement agency. Do I have that right?
I'm sorry, could you repeat the question, Your Honor?
The state trooper did respond, because I think your driver requested a state trooper. State trooper shows up and then leaves, and it gets referred to another law enforcement agency for investigation. Do I have the facts right there?
Well, I believe that the claimant said that she called 911, and the state trooper responded. And then the state trooper affirmed that this took place on the I-490 on-ramp.
Is I-490, is there any evidence that I-490 is part of his beat? He
Well-
said 390 inner loop, he didn't say 490.
Well, the 390, the inner loop, and then the 490 so inner loop, he said that he was on his third circuit around, and he had to get to the 490 to get on his beat.
He was on his way to his beat. Wasn't quite yet on his beat, but he was on his way to his beat, sounds like.
Again, relying on the statement, Mr. Mobilio did state that at the time, his beat included both the 490 and all ramps on both sides. That's in the record, Your Honor. He also testified that he was actively salting at the time, and therefore we think that as a matter of law, he was entitled to the reckless disregard standard under Vehicle and Traffic Law 1103B. As to whether or not we feel that the Court of Claims properly determined that the state established as a matter of law that Mr. Mobilio was not operating the snowplow with a reckless disregard for the safety of others. The reckless disregard standard requires a person has acted in conscious disregard for known and obvious risk that was so great as to make it highly probable that harm would follow. Here, the state's evidence established that Mr. Mobilio's conduct did not rise to the level of recklessness. Mr. Mobilio has driven that route for several years. He was driving under 35 miles per hour, which is well under the speed limit. He used his turn signal while changing lanes, and he checked his mirrors before changing lanes. Claimants did not offer any evidence to create a triable issue of fact with respect to that issue. And to the extent that they argue that the expert opinion created a triable issue of fact, that's simply not true. Here, the report concluded summarily that Mr. Mobilio was driving quickly, but that's primarily based on that stretch of highway, the I-490 on-ramp. And here, Mr. Mobilio, again, it doesn't refute the testimony that he was driving under 35 miles per hour, and that he put on his blinker so that he could shift over to the far left lane.
I think we're pretty aware of your reckless disregard arguments. We don't even get to that, though, if we still have questions on the on whether you met your burden to establish your entitlement to the benefit of this application of the statute in the first place.
Okay, well, I guess we will rest on our brief.
Thank you. $728, On the Water Production LLC versus Glinos.
Morning, Your Honors. May it please the court, my name is David Silverberg. I represent the appellant, Nicholas Glinos. We're appealing, granting a motion for summary judgment in the lower court.
Are you saying, Mr. Steinberg, there are questions of fact here?
Absolutely, Your Honor.
And do the questions of fact involve how much is owed to your client?
That is one of the two primary issues.
What is the total amount that is owed to your client? What's the price for this boat?
We alleged in our counterclaim that there was over $100,000 still owed to our
But
client.
based on what principal amount?
Based on a contract that was verbally entered into,
What's the amount?
the gross amount of the
Correct. I mean, you're saying that $100,000 is still owed. What was the deal? For how much?
Well, that's the other question of fact, but it's our position.
That's not good for your client. If there's a question of fact about how much he was owed,
No,
there's
no,
no contract price.
The question that I was saying is, what were the terms of the parties, what were the terms of the contract that the
What does
parties
your
had?
client allege was the price of the boat?
$399,900 plus other terms and conditions.
But I mean, in terms of just money in your client's pockets. I know that there was insurance, I think, and I think there was paying down the lien, et cetera. But you're saying your client was owed $399 and the balance is roughly $100.
Correct.
So that means he's been paid only $299.
Correct.
And you think the record will reflect that?
Yes.
Okay.
It seems like the pivotal factual dispute here is whether what the parties agreed to at that pizza parlor meeting in the spring of 2015 in Ohio. We had an initial contract that was replaced by another contract, and then there was another agreement to continue on. And then we get to years later, April or May of 2015, and the disagreement there, nobody took any notes, it doesn't sound like, or if they did, they didn't preserve them, it wasn't reduced to writing, but your client's claim and Mr. Evans' testimony is that the plaintiff here, who was trying to buy the boat, agreed to forfeit all payments that were made prior to that date.
Correct.
Now, the plaintiff says, that's absurd, I would never have done that, didn't do it. In your view, that's a factual issue. Would you agree that that's a factual issue that needs to be litigated at trial?
Yes, Your Honor.
And we can't resolve that. It does seem kind of far-fetched that somebody would pay hundreds of thousands of dollars towards a boat that was initially for, the purchase price was $309. It seems kind of absurd to think that he would just say, okay, forget about all those hundreds of thousands of dollars I already paid you, in addition to the storage fees, insurance, and all that stuff. But if it's not incredible as a matter of law, we have to send it to the jury, and that's what you think should happen here.
That's correct.
And Mr. Steinberg, just to follow up so I understand it, looking at the briefs, I see no argument by anybody that the statute of frauds would preclude the pizza parlor oral agreement, correct? That's not an issue. Everyone seems to say there was something that was agreed to and it amended the written contracts and everybody's good with that. Do I have that about right? I don't see there being any debate about that oral agreement is not enforceable, correct?
I don't believe anybody's argued it either.
Just to confirm, in case I missed something. It's not a trick question. I just want to make sure I've read the
I don't
briefs
disagree.
correctly. Right.
Something that's been bantered about amongst counsel, but never made it into the papers.
Right, so you think this should go to trial if the agreement was such as your clients say, then there's no conversion because they still owned the boat at that time.
Correct.
And so those issues should go to trial altogether.
Yes, Your Honor.
I think we understand that.
Thank you.
Thank you.
Mr. Sam. Morning.
May it please the court, Bradley Stam. I represent the defendant, appellant Ryan Evans.
Mr. Stam, same kind of question for you, so I can, for my notes. Your client claims that he is owed $45,000 for commission.
Yes, Your Honor.
And when was that agreed to?
That was agreed to in the beginning.
Right at the beginning, right?
However, as Your Honor knows, and I pointed out in my brief, the plaintiff originally thought, pardon me?
I just read your brief a second ago, and it says that you rely on what the oral agreement was in the pizza parlor discussion.
Yes, but the terms of the agreement, originally the confusion was the plaintiff thought that Glinos would pay my client. My client honestly doesn't care who pays him. The point is, at the pizza parlor agreement, it was testified to by the plaintiff, as Your Honor knows, agreed by everybody in this case, he was going to pay the commissions.
For
Riggs,
$45,000?
For $45,000.
And was that premised on a percentage of the $399?
Yes, yes it is.
So you agree that the amount owed to Glinos is $399, and that's how you calculated your commission?
Yes, however, the piece about Glinos, there was additional factors, as Your Honor has already pointed out, that was testified to in the
Just
record.
meaning money in his pocket. You wouldn't be entitled to a commission upon how much was paid to the bank or paid to the insurance.
No, my guy had a deal, and he's still waiting for his money.
Based on the $399 owned to Glinos?
Yes.
Okay.
Anything further?
Does Your Honors have any questions? Thank you very much.
Thank you. Mr. Ferdman.
May it please the court, Michael Ferdman, Barclay Damon for the plaintiff respondent. Justice Kern, the point about the pizza parlor agreement, what their position is that in April of 2013, there was a breach of the contract that terminated the contract. That's their position. Otherwise, why would you need another agreement later? So their position is the contract's terminated, and yet another $93,500 were accepted, paid and accepted on regular basis payments between April 2013 and the pizza parlor agreement of April 2015. And incredibly, the position of Glinos is, well, that occurs, that payment is in the hope that, literally, that's in their papers, in the hope that the plaintiff could get back into the deal. So I guess what they're saying is, actually, let me quote from their papers. Plaintiff made additional payments in hope that it could still buy the boat. In other words, just a gift. Here, Glinos, here's $93,500. I hope you like me enough to someday sell me the boat. Well, that's ridiculous. So what we actually have is, it's not a gift, it's a it's a clear manifestation of the party's intent to continue into the original August 30th, 2012 contract, and there was no statement by...
Was that for the $349,000? Because I understood you were relying on the second contract, the second written contract.
Yes,
Okay.
the August 30th, 2012, that's $349, and it was amended orally at the pizza meeting.
And you have no problem with that oral amendment?
That's correct, Your Honor. In fact, I briefed that because there was performance thereafter, payment and acceptance.
You got the boat?
Yes, we did. And so that oral agreement is not subject to the statute of fraud because both parties performed thereafter. Questions?
So do you agree that there's a conflict between the deposition testimony of Mr. Riggs and that of Mr. Glinos and Mr. Evans as to what was agreed to at the pizza parlor meeting? Do you agree that their testimony diverges in a significant way there?
Yes, I do. But, Your Honor, what we have is the actual performance by the parties of continued payments, Glinos accepting the payments, and never declaring a default. And that occurred for the 2 years prior to the meeting. And so what their position is that $93,500 that were paid over those 2 years were a gift, should be forfeited. It makes no sense. Not only does it make no sense, the law is that the party's actual performance of the continuation of the August 30th, 2012 contract is a continuation of the contract. It's a manifestation of their intent to continue the contract.
But how would we, if we were to rule your way, what would we write? That their testimony is incredible as a matter of law, or it's belied by the prior contractual relationships? How do we get around their sworn testimony that there was a forfeiture by Mr. Riggs of the prior payments?
Because, Your Honor, because what we actually have is the performance itself, not the testimony, but their performance. Payments and acceptance of payments, and the boat being provided to our client, in the possession of the boat, finally provided to the client.
Okay.
Anything further? Thank you.
Thank you, Your Honor.
729, Stuber versus Stuber. Justice Bannister is recused.
Good morning, Your Honors. John Sergala for the appellant, Russell Stuber.
Mr. Segala, good morning, sir.
Good morning.
Just so you know, where I'm focusing is, for my part anyways, is in your points 4 and 5, I think it is. Basically, you're saying this bare bones complaint doesn't state a cause of action for anything, and if the extent it alleges any facts is directly contradicted by the evidence that you were permitted to put in on a motion to dismiss under these circumstances, and therefore the complaint should be dismissed. That's sort of we get into res judicata, then we have to compare, well, was a fraud cause of action to set aside an agreement, actually barred by the agreement itself? Well, that can't be true logically, I don't think, but forget about that. But your fundamental point, and don't let me put words in your mouth, but as I read your brief and your reply brief, that seems to be, and now they, according to your argument, they conveniently now say, well, now they're referring to things that happened after the closing on the PSA, but that's not in the complaint. Do I roughly have it correct? That's sort of a fundamental point here.
Yes, with regard to the fraud allegation, because we have to focus on the actual unverified allegations in the complaint. And where it is specific as to assets and to transactions, those assets and transactions were actually addressed in the property settlement agreement and in the documents supplied to the court in the record. It is shown that those were addressed by counsel.
Which is the documentary evidence you put in.
Exactly.
That was sort of my point, was that, and it's not just fraud, it's unconscionability, it's duress, it's all kind of rolled up into one because there's no separate causes of action here. So your basic point is, I said, they don't state a cause of action to the extent they allege any facts. I've directly contradicted them.
That is, yes, that is a point. But before you even get to that, we do have the ratification issues. I mean, she accepted $1.75 million when the property settlement agreement was signed.
Is that just a point of clarification? Is the 1.75 in addition to the $1,025,000 that she got at the outset?
Yes, so exactly. That's right.
So 2.7.
Yes.
Out of this agreement.
Well, if you look at also what was supplied to the court, were the 6 months of negotiations going back and forth. There was over $1 million that was alleged that she took from marital assets to herself during the pendency of the divorce. So that was factored into the negotiations with counsel when we reached a figure. So arguably she received more.
What did she walk away with total? She was not I don't think she worked during the marriage.
She didn't work during the marriage. She brought no assets into the marriage.
Prior to the marriage, and they had this agreement that she was going to get 40% of any increase. But she walked away with You're saying more than 2.7 million?
Yes, she bought approximately over 3 million that she walked away with,
Okay.
which is reflective of, as you recall, there's also a pre-nuptial agreement in this case, which talked about a 60-40 split. And the property settlement agreement also reflects that 60-40 split. No one's ever challenged the prenuptial agreement.
60-40 split of the increase.
In the increase.
Not of the total assets.
That's right. So the property settlement agreement sort of takes that 60-40 and sort of expands it, but follows the same framework for whatever the antenuptial agreement didn't specifically cover. But as far as the ratification issue, I mean, 2 years go by, she accepts the benefits and makes no complaint. She also, apart from accepting the benefits, complies with the agreement.
Not totally.
Not totally, that's right.
You do have counterclaims.
Yeah, exactly. When it came for her to actually pay her share of taxes, she did not. And we were.
But she accepted all the benefits.
She accepted the benefits, yes, she accepted the benefits, but she also cooperated in the transfer of the deeds of the property with him. So that was a recognition that he was entitled to some benefits under the agreement, and she did perform that.
And you cited some of the cases supporting the ratification argument in your brief, as I saw.
I have, and I'd like to apologize to the court and to counsel here for an error in my citations in the brief in Smith versus Smith, which has a somewhat similar factual pattern. But in my brief, I say 29 miscellaneous third 126A. It really should be 1226A. So I missed the two there, and I do apologize for that. If there are any further questions?
Thank you.
Okay.
Mr. White.
Good morning. May it please the court, Justin White on behalf of the plaintiff respondent. Our position basically is that maybe the defendant here jumped the gun and brought a motion to dismiss under 3211, several subsections, and particularly the reliance on the documentary evidence under subsection 1. We don't think it's so apparent, so manifest, so unrefutable that he's entitled to summary judgment as a matter of law. Maybe downstream after discovery is conducted, maybe after further facts are brought to light, then you come back to the court and you bring your motion. But to say that what they brought forward as documentary evidence, entitling them to a matter of law, is a stretch here.
Can I ask you this, for the fraud or misrepresentation, the allegation is that he hid assets or he failed to disclose the true value of assets at the time of the agreement. That's what the general allegation is, your clients. Wouldn't the complaint have to identify what assets she's talking about that was either hidden or undervalued, and that she learned about it subsequently? Wouldn't you at least need to allege that to get your foot in the door?
And I think that's, Justice Lindley, I think that's done in paragraphs 11 and 12 of the complaint, where she identifies a specific asset that, in her view, wasn't fully disclosed to the extent that payments downstream were not identified. So he sold USNS, I think was the name of the company. However, the tax return showed a $2 million consideration. Well, her suspicion is, alleged upon information and belief, that there were downstream payments to him that came through what we might term the back door or the side door. And I think that's enough.
This transaction happened before the property settlement agreement, though, right?
Correct. Yes.
And she doesn't say in paragraph 11 or anywhere else that she learned of that subsequent to the agreement.
Well, let's imply that. And let's assume, and again, we're dealing with a motion to dismiss as a matter of law, that these claims are true. What if it comes to light that indeed he did not disclose the degree of consideration received and the amount of payments that he was getting later? Let's assume that. If true, doesn't that give her a good basis to set aside the agreement on the basis that it was not disclosed?
If you had alleged any facts having to do what was discovered subsequent to the PSA and the closing, that might be possible. But everything that I understand is alleged in your complaint has to do as of the time of the closing or before.
Well, I
I know
don't...
you say in your brief at page 12 that what was learned subsequently is the subject of the plenary action. But I don't see anything alleged in the complaint at all about what was subsequently, to use the language you're learned.
No, Justice Kern, I get your point, but isn't that what discovery does for one? Allows a litigant to confirm his or her suspicions of what...
Yeah, there's 3016B there too in fraud, and this is fundamentally a fraud case. So I've got to look at it. I'm still exploring it.
Your basic argument is that this is just premature. It's summary judgment, that you should be allowed to explore, do some discovery, and then let them bring a motion.
Yes, Your Honor.
Thank you.
Thank you for your time today.
731, Spence versus Kitchens.
Good exactly afternoon, Your Honors.
So, Mr. Ryan, what you're really trying to do is say you can't find in this record as a matter of law that the vehicle here was entitled to the reckless disregard standard.
Beyond that, Your Honor, I think what I'm really saying is that if you want to have VTL 1104 apply to you, you have to meet the exceptions. And I guess the way that Your Honor phrased that is what gives me a little hesitation, because it's uncontroverted that there was no red light here, right? And sometimes the easiest answer is the right answer. And the statute says...
It was a courtesy light or whatever they called it, right?
Yeah, and Your Honor, like, this is one of those things where we don't have a case directly on issue with this point, with this green courtesy light. And the reason is just because it doesn't make sense. It doesn't fit. And because of that, as you saw in our brief, we're forced to go through all these chutes and ladders, nuances of the way that this law is done to shut down any way you could possibly look at this. And so, as far as what's on this record, bottom line, Your Honor, no red light, uncontroverted, that's it. 1104 can't apply.
We have some other things, don't we? The fact that it wasn't a town vehicle, the defendant was driving his own vehicle, and he wasn't on that call.
There's so much going on here, Your Honor, and I think that I can simplify it, okay? And I'd actually, you know, I'm pinch hitting here. I read over this People v. Levy case that both defendants rely on heavily here, okay? And I'm thinking maybe this is bad for us, all right? This is a personal vehicle, et cetera. Besides the fact that it's a criminal case based off of basically a traffic violation with being able to put on a red light on your personal vehicle, what it actually does is it lays out the burden that they should have to show that the personal vehicle is an authorized emergency vehicle. And we make that point in our brief that there's actually a section of the public health law that says you need to do these different certifications. And if you look at People v. Levy, the court says, hey, you know what? We look up this license plate number and the certifications are there. Not a single certification is here. And then after People v. Levy, the second department who decided People v. Levy decides Nicosia v. Schultes. And that shuts down any argument about the personal vehicle here, because there's a statutory process to have your vehicle become an authorized emergency vehicle. You cannot just unilaterally decide, I'm an emergency, volunteer emergency personnel here in Nicosia. It was a volunteer fire personnel. My personal vehicle is an authorized vehicle.
He wasn't assigned to this. He doesn't appear to have any medical training either. From the record, he's just a lay person rushing to the scene of a medical emergency. But let's assume we agree with you. Then we just get to negligence. Do you win as a matter of law on negligence? You want to speak to that issue?
I would, Your Honor. And so initially, we just moved for negligence, not proximate cause, not comparative fault. All right, there's a lot of conflation that's going on with that in the
So there still has to be a
opposing
trial, even if we said as a matter of law, this defendant was negligent.
papers. Right.
You still have to have a trial on causation and comparative fault.
And I agree with that. That's a concession. So I'm going with Rodriguez separating negligence, proximate cause, comparative fault, damages.
So why don't we talk about the evidence of negligence that we have here?
Yeah, and so, Your Honor, again, uncontroverted evidence from everyone besides the defendant is that my client was stopped waiting to make a left-hand turn. This is my client's testimony. This is also the police officer's testimony.
I'm sorry to interrupt you, but all those facts are in there. I mean, it looks like if you look at just the testimony of the plaintiff, and if you piece together some of the testimony, if I think it's the officers, you'd say, wow, that's a pretty strong case. But as I recall, we have cases out there that say something to the effect of, that in a summary judgment motion, when you're moving for negligence, and the same is true in the defendant case, that you have to essentially assume the truth of the testimony by the defendant. You put it at issue, unless we can somehow find that as a matter of law, it's incredible that it's contradicted by so much evidence that, or if it's contradicted by a previous deposition or affidavit. We don't have any of that here. So if we assume the defendant's testimony is true and give him every favorable inference here, don't you think that's a question of fact and negligence?
And Your Honor, I've thought about this because as a plaintiff's personal injury attorney, I've got to be careful on this. Credibility is a big issue, right? But what I would like to do is point Your Honors to the Carthmore case when it's all physical evidence that's available as well as the testimony that's done.
No, but doesn't the property damage here support either version of the accident? I mean, either the defendant was kind of off a little bit to the shoulder and made a left turn into the plaintiff's vehicle, or he was in the southbound lane and turned left into the plaintiff's vehicle. So it seems that the physical damage supports really either version of the happening of the accident.
And I understand that, Your Honor. I was actually, if I could just, the physical evidence that I'm talking about is the actual size of the road, okay? And then if Your Honors go back, and I know you've read the record thoroughly, but if Your Honors go back and you actually look at what Defendant Kitchen says, okay? There's this, and again, you clearly know that I think this is incredible. My client pulled off to the side of the road, then all of a sudden just decided to dart back across, right?
Well,
We know
but
that's his testimony.
Bishop also, Officer Bishop said that there was traffic in front of the plaintiff, traffic behind, because there was this incident up ahead, also in the southbound lane. And he said, yeah, traffic was pulling over the shoulder to let people pass.
And I understand that, but first of all, the defendant doesn't have a right to pass unless he's an authorized emergency vehicle, right? So we know that he...
Well, so this road, you're talking about the physical setup of the road, the lanes were separated by a white dotted line.
Right.
So anybody can pass, anybody can go in that northbound, if it's safe to do so, right?
And that's the key part, Your Honor. And what I'm asking you to do with the defendant's testimony, I'm just going to get right to it, okay, is that his testimony is that my client never made it over to the shoulder, all right? My client's vehicle was never passed out of the lane of traffic.
I wrote down that he specifically said that the plaintiff came from the right shoulder.
And Your Honor, if I had the record in front of me right now, I would be able to show you the part where he actually says, I think that the driver's side wheel was not over to the right shoulder.
Additionally, okay, go ahead.
Just additionally, his testimony is that there was never a stop in the vehicle.
Let's assume that he was still in the southbound lane. The defendant says he had not activated his turn signal. The plaintiff says he did. There's no one else that gives any testimony about a turn signal. If he doesn't have his turn signal on, it might be safe for the defendant, for Kitchens, to go into the left lane and pass.
But passing, Your Honor, in a different lane like this is not, it might be safe, it has to be safe.
But we're supposed to decide that as a matter of law?
I think
when there's a question as to whether the turn signal was on, so question whether the defendant knew your client was going to turn left, and there are other vehicles that perhaps have pulled over, and he sees a clear route to pass your client in the opposing lane to get to this incident. I think about like driving on country roads where, I'm behind a tractor trailer, who moved slightly to the right, and I pass that vehicle because I want to drive faster than 40 miles an hour. And I do that, I can do that with safety and legally, if it's safe to do so. How is that any different than what may have happened here?
And then, Your Honor, if there was a vehicle in front of that tractor trailer that you did not see because you could not see it and you made that, despite your good faith effort, you would still be at fault for an unsafe lane change.
I don't disagree with that, but that's not what happened here.
I understand, but that's what I'm trying to say is that the law does not say, you know, that it might be safe or could be safe for this lane change, right? It needs to be safe.
Right.
And that is the risk that you take when you make that pass, right? And I think that's what I'm saying here is that it's undisputed that he is not in the proper lane of traffic, right? We have northbound,
Right.
southbound, and he goes into southbound.
But you're allowed to be in that other lane to pass if it's safe to do so.
If
And you're
you're-
saying as a matter of law, we could decide that it wasn't.
I believe so, Your Honor, by the language of the statute as well as the facts that are presented. And the only other thing that I would just ask Your Honor to look at with this is the testimony from the police officers that ended up ticketing him for the exact same thing
I
we're
looked
talking
at
about.
it.
And I know that that is not something where you have to rule negligence as a matter of law. But coming back to the Carthmore case and what we're talking about is something that his testimony is so incredible that it can be disregarded. That's what I would encourage that
Pretty
Your
high
Honor
bar.
looks at. I do understand that, and like, as I said to Justice Curran, especially as a plaintiff's attorney, this comes up all the time. I mean, credibility means we're going to trial, right? But Your Honor, I do think that when you do decide to leave your lane and attempt that pass, that onus stays on you to make sure that it's safe regardless of what happens here.
Okay.
And I would rest on that as far as the negligence claim. Thank you, Your Honors.
Thank you.
Good afternoon. May it please the court. Melissa Vinkton on behalf of Respondent Kitchens. And the first thing I wanted to point out is, as the court recognizes, there is an issue of fact regarding the accident, whether negligence or the reckless conduct standard is applied. That's a separate issue, is whether the standard is applied. But there is an issue of fact as far as what happened in the accident and summary judgment.
What about the plaintiff's argument that, you know, I mean, the basic argument is there's no question that Kitchens was was traveling south in the northbound lane when this collision occurred. And he says we should decide that's negligence as a matter of law. How do you respond to that?
As Your Honor recognized, there is a dotted line in the area where the accident occurred, and my client's testimony does deserve some weight here. He is the non-moving party in this, and so his evidence should be looked at more favorably. He testifies that there is no turn signal. The vehicle has moved over, as has other vehicles, so that he can pass. He was allowed to pass. There is not negligence as a matter of law here. There is an issue of fact, a negligence.
I think counsel's point was that sort of the proof is in the pudding. It wasn't safe. There was an accident. How can you speak to that?
I would respond to that in the fact that there was no indication to him that the plaintiff was going to turn. And if the plaintiff had not turned, there would not have been an accident. And that is why there is not negligence as a matter of law. From his perspective, he was safe to go around.
Your overall argument, though, is that negligence doesn't matter because they have to prove recklessness. Are you going to argue that this morning?
Yes, Your Honor. We do believe that our client is entitled to the protections of Vehicle and Traffic Law 1104. Mr. Kitchen was trained and authorized to use his personal vehicle as an emergency vehicle for Eden Emergency Squad. He was responding to a call. This argument that he never arrived at the scene.
What do you mean by a call? Tell us.
He was in his capacity as an emergency responder.
That's not my question.
Oh, he received a call.
About the call. Did he get a telephone call? Did he get something on his phone? What, was it directed towards him? I just want some details about the call.
Yes, Your Honor. I believe it was over the radio. That he had access to a radio with emergency calls.
He heard the call go out.
I'm sorry?
He heard the call go out.
Yes.
He was not directed by anyone to go out. He did it. He could have stayed home, been within his duties. He voluntarily went out. He has no medical training. You agree with that?
He is trained to respond to emergencies. At that
So
time.
he's not a medical personnel. He's driving his own vehicle. He doesn't have any red lights. He has, were the green lights on top that he put up on his own?
Yes, flashing green lights.
And that's an emergency vehicle in your view?
Well, the Vehicle and Traffic Law 101 has a long list of defined authorized emergency vehicles, from ambulances and police vehicles to correction vehicles, civil defense emergency vehicles, sanitation patrol vehicles. Those are authorized emergency vehicles according to Vehicle and Traffic Law 101, and we submit that there are many vehicles there that do not have red lights.
And now, I heard it described somewhere in the record as a courtesy light.
Yes, and we would also submit that that is not the law. That is coming from lay opinion testimony about what a police officer believes should be accorded to the green light. It does not come from the New York State Vehicle and Traffic Law.
Do you think, is there any regulation, vehicle and traffic law or anywhere else, that authority that says a motorist has to pull over in response to somebody who puts green lights on top of their vehicle?
I don't have the answer to that question in front of me right now, but I would submit
Your client
that,
testified to in the negative. His understanding was that it's a courtesy light and no one's required to get over.
yes, and I submit that the issue is not really whether people are required to pull over, but what standard of care applies to him as a driver.
He was coming back, I think he was a mechanic, I think, one of the local car dealerships, as I recall, and he was down seeing his son's performance or something or other at the elementary school down in Eden, and it was on that way back to work, as I understood it, that he heard the call on the radio. No one from the emergency squad knew he was going, he didn't inform anybody. And he wasn't on call that day. They do have a call list where they assign people to specific days for their 600 or 800 members, whatever they have.
Yeah.
So he did this entirely on his own.
Well, I disagree somewhat in the fact that he was operating in his capacity with the Eden Emergency Squad, and although no one called him and said, hey, go to this emergency, it was part of his training and his understanding that if a call comes over the radio, that you can go and provide assistance, and he volunteered, yes, to go
Well,
help
they
at
had
an
police
emergency.
officers where, I'm not sure what he expected to do once he got there without any medical training. They already had people at the scene, but that may be totally irrelevant to our legal analysis.
And is that a 24/7 license, to respond to anytime he gets a call or hears a call, he's got the authority to race to it?
Well, I submit that he has, in his role, that he volunteered to help people in emergencies.
It's a voluntarily assumed duty.
Yeah, it's a voluntarily assumed duty, that when he is able and he hears people need help, that he can go and provide whatever assistance he can pursuant to his training, pursuant to his certification as operator of an emergency vehicle, because Mr. Kitchen was also trained to operate the actual ambulance. So he knew this was part of his role, that this was not just someone who heard there was an emergency and stuck some light from Walmart on the car and zoomed down the road. I mean, he had training, he had a role with the Eden Emergency Squad, he went to help, and we submit that different rules apply to emergencies. That's recognized by this court and the laws of New York State. Different rules apply in emergencies. Here, Mr. Kitchens, whether he, with respect to what help he was going to provide, he was trying to help. He heard a call, he was on his way, he did what he was trained to do, he activated his flashing lights, and he honked his horn, and he saw vehicles pulling over to the side of the road, so he went around where there was a dotted line, and it was safe to do so, to try to help someone. Does Your Honors have any other questions?
No. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Kevin O'Neill for the defendant, Eden Emergency Squad.
So I have a question for you. In your cross motion, you take the position that any liability of the client is vicarious, so that if the action against Mr. Kitchens is dismissed, the action against your client should be dismissed, right?
Correct.
So
Yes.
you agree then that your client will be vicariously liable if Kitchens is held liable?
That is my understanding of the law, yes.
Okay.
But just
So
like
you're
an
not-
owner, operator, or employer-employee situation.
He was driving his own vehicle though, right?
Right.
Okay, all right.
But you still embraced him as your person?
Yes. The only thing I would add, I think Your Honors have asked a lot of questions and read and listened to counsel already. The reason that Mr. Spence said he was He said he was stopped with his left turn signal on in the southbound lane. He said the reason he did not turn was because there was oncoming traffic. If there was in fact oncoming traffic, which is not testified to by anyone else, then one would think there would have been a head-on collision between Mr. Kitchen's truck and that oncoming traffic, because he had to get over
That's the lane he went
across the
into.
lane before and would have conflicted with those vehicles. Unless your honors have any other questions? I'm finished.
Thank you. 732, Sareva versus New York State Thruway Authority.
Good afternoon, Your Honors. Raul Martinez for the New York State Thruway Authority. The two regulations, or two industrial code regulations at issue here, essentially ask to employers or owners to fix things that
They're
are broken.
sufficiently specific, right?
Right.
Under our case law?
They're right. So these two regulations, one, they're specific enough to bring a cause of action, but at heart, what they do or what they require is to fix things that are broken that could hurt a worker because of their being broken. The PVC pipe here was not broken. It's a conduit to allow grit and debris to go through from the vacuums over to the ARS unit to be recycled. So there's nothing inherently wrong with the PVC pipe.
Well, they say, of course, that there was something wrong with the pipe and that it wasn't sufficiently grounded, that the grit comes through and it creates, so there needed to be some grounding there, and it wasn't.
And I get that point, but the difference is that the PVC pipe is a tube. The tube was not broken. It was not letting any of the grit out to spray anybody. There was no odors, no gases, nothing. What the lower court did is impose an additional safety standard that's not inherent to PVC piping. It's like adding a second guard to a machine that already has a guard, and that imposition is not found anywhere in the code. So it's basically making something safer without authority in the code. And the code is comprehensive in many, many facets in terms of what is necessary to make a workplace safe. And nowhere in the code is grounding for static electricity that is the collection of electrons on a surface, which can happen almost anywhere, including this courtroom. None of that is regulated. And so what the lower court did was essentially impose an industrial code regulation created out of cloth and pose it on this PVC pipe where it had no authority to do so.
Well, time out. Your summary judgment was denied. Whether or not this ever gets charged to a jury or even goes to a jury, we don't know yet, right?
That's true.
Excuse me, not jury, but to the fact finder.
Right, so both parties moved and both parties were denied summary judgment, yes.
So what the court said there may not necessarily control a trial.
That's true.
Okay.
That's true, but the Thruway's authority is that what the court did was create a safety requirement that has no basis in the statutory framework of the industrial code. And then in addition, my other points in the brief were then under section 2315, really the essence of that regulation is by and large and through the case law addressed to safety features that are not in good repair. PVC pipe is not a safety feature. And with regard to 2329, really what we have here is one of these Sesame Street, which one of these things doesn't belong, and the ARS unit is really not at all anything like any of the instrumentalities that subsection seeks to regulate. Unless there are any questions, I'll rest on my brief.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Lisa Como for the claimant respondent.
As I understand your argument as a respondent, basically it's that these regulations are sufficiently specific, as we have found.
Yes.
And they're potentially applicable, and they cannot be found as a matter of law to be not potentially applicable at this stage of litigation.
That's right, Your Honor. Their argument was that as a matter of law, they simply could not apply to the facts of this case. The Court of Claims correctly, we submit, found that they had not met their burden in that regard. And with respect to the application, the two regulations are very similar in many respects. under the Court of Appeals decision in Misicki, which is where this all sort of, came from originally, it talks about 23-1.5C3, specifically talks about equipment in use and safety and equipment in use and that needs to be repaired.
So you're saying that equipment doesn't have to be safety related under that, because he reads it to mean all safety devices, equipment, and safeguards, meaning the equipment is tied to safety.
Yeah.
You're saying, you're separating the equipment from the safety.
Well, not necessarily, yes, but not necessarily, and if I may just explain. The regulation by its terms applies to all equipment in use. And as I think
Safety or not, safety related or not?
Well, yes, I think any equipment in use, if it becomes damaged, broken, I mean, there's sort of a whole universe of possibilities out there. Almost anything can become dangerous if you're using it when it's broken. And this, of course, is in the context of abrasive blasting with grit, which in itself is a pretty hazardous activity.
Then why would they
But-
put the word safety in there? Why wouldn't they just say all devices, safeguards, and equipment?
But it also was a safeguard that we're talking about here as well. I mean, there's no question it applies to all equipment in use, and it applies to it becoming, out of repair, broken, unsafe, et cetera. And the way that happened here is because of the improper and inadequate grounding. And when counsel talks about a PVC pipe and limiting the focus to just that pipe itself, I think it's incorrect. It's really a misinterpretation or a misstatement of the equipment that we're talking about. This is an entire grit recycling system. It's a tractor-trailer, truck-mounted unit. It's diesel-powered. The PVC pipe is one of the returns. I mean, I know it's all laid out in the brief, so I don't want to go into too much detail unnecessarily. This is not just something that we're pulling out of thin air, that it needed to be grounded and that it was unsafe for static electricity without it. In fact, the plaintiff's, Mr. Topsidis of the claimant's employer, he testified that was the case. I mean, he specifically says, he talks about the need for grounding, page 283 of the record, 293, 294. He thought that the PVC pipe actually had some sort of internal ground wire, which it did not have, but he acknowledged it needed to be grounded. He thought it was grounded, and afterwards he did put what he said was an additional ground wire of some type. Then there was a lot of dispute back and forth between the expert affidavits as to what type of grounding should be done, what the result could be, how much static electricity could be generated. But I think it's actually undisputed on this record, including from the defense expert, that the PVC grit return can generate static electricity. There is a dispute as to how much and what effect it could have, and we have various proof
And
about
they've done
that.
it on 2 prior occasions, one very recent.
The co-worker test, we have an affidavit, I think it was, from the co-worker, Mr. Benvenuti, who said it happened to him a day or two previously. But those are factual questions, of course, that will be reserved to the time of trial. But with respect to the regulations themselves, I think the Court of Claims was simply just correct in finding that they could apply here. We actually would submit that they absolutely do apply here.
But that's for another day.
Yes, it is. So with respect to, again, going back to the safeguards, so you can't just look at a PVC pipe and say, oh, well, it was fine because it wasn't broken, it wasn't cracked or something. You have to look at what it was being used for. And what it was being used for was the return of the abrasive grit, which generates the static. It wasn't properly grounded. So that is the equipment that was unsafe and that was not in, if you want to say, not in repair, not in the sense of, again, the pipe being cracked or broken, but it needed to be configured properly. And so that actually is in the defendant's own submissions on their motion for summary judgment. You can see those questions of fact. And moreover, their own expert, again, acknowledged that static could be generated, but he never addressed the testimony of the witnesses whose depositions were before the court on the motion. He didn't address whether or not it could have happened the way the plaintiff testified. So when the inquiry today basically sort of cuts off at the point of, did the Court of Claims correctly determine they hadn't met their burden? And I think that's absolutely the case on this record. Just briefly, with respect to 9.2a, their argument below was that it only applies to certain types of heavy equipment. They sort of switched tracks a little bit on appeal and argued that it has to be motorized equipment. In this case, it actually was both. As I mentioned earlier, you can't look at the PVC pipe in a vacuum, no pun intended, because it was part of this entire recycling system. And so I think we do go through many cases with specifics in our brief that talk about the types of application. And finally, I would just like to point out their ultimate argument, which is that because there's no specific industrial code regulation, such as the regulation pertaining to electrical circuits, because static electricity is addressed in that regulation, that somehow means that the industrial code was not intended to regulate that kind of a situation. I would submit that if that were the case, then the two regulations that we're talking about here today would have no meaning. There are many instances, which again we do point out in our respondent's brief, where as long as there's no conflict, that is, as long as there's no positive directive in another industrial code regulation that's going to conflict, there's absolutely no reason why 23-1.5C3 or 23-9.2A can't be applied when equipment is defective as it was here. So unless there are any questions from the court, we respectfully ask the court to affirm the order appealed from.
Thank you.
Thank you.
7:33 in the matter of Gina R. Good morning, or good afternoon.
Good afternoon. And may it please the court, Gary Muldoon for Christina Rosa. In this neglect proceeding, what was missing was evidence of neglect. The department's case was based primarily on safe sleep practices, but nothing of the sort was shown. The judge made a specific finding that the mother violated safe sleep practices, but what is it?
Yeah, I mean, I saw I read most of the record, and they were sleeping, she was sleeping with one or two kids every night. Some of the other kids were sleeping together in the same bed, et cetera. It didn't appear that there was enough room.
Oh, true, Your Honor. But what I have presented is that the evidence is bad, and also the science, so to speak, in this area is bad. I've quoted at extended length James McKenna, who is the head of the baby sleep infant clinic, and he says that in all cultures, almost all cultures, that a mother sleeping with a child, co-sleeping, there is nothing wrong with that at all. It is encouraged.
Or a father. Look,
Or a father, yes.
I agree with you that co-sleeping, if that's unsafe, then a lot of parents are going to be hauled into family court. But here it sounds like it's not just co-sleeping, it's the loose blankets thing, right, which caused the death of the other, allegedly, we don't know for sure, but was apparently involved in the death 2 years earlier of another child here, of the mother. And that seemed to be the unsafe, is not sleeping with the baby per se, but the loose blankets. What do you say?
I agree, Your Honor, that that's the second issue in the case, and that is brought up by respondents in their brief. The problem is this. Number one, there was another child who died, 2017. That child died during sleep, apparently.
Had
That case was...
Had a blanket over, like a big comfort or something.
Okay. That case was adjourned in contemplation of dismissal. That evidence should never have been considered. It's dismissed. Yet the judge takes this box of documents, which is point 2, I believe, of my brief, and says, well, I'm going to consider everything, and does consider this information from the prior death of this, the tragic death of this other child. And I think that's improper.
But there was a number of instances where there's a number of instances where there were observations made of the 3-year-old, or the child who is now 3, being wrapped in a loosely wrapped fleece blanket, and the mother kept being advised not to do that.
Well, Your Honor, respectfully, when it comes to dealing with a child who is 3 years old, having a blanket, including a blanket over the head of a child, is not an unsafe sleep practice, I think, by any stretch of the imagination. Actually, Dr. McKenna, in his book, says that after 4 months, the incidence of SIDS, sudden infant death syndrome, decreases dramatically, and after 6 months, even more so. So what happens with a 3-year-old child, I think that's Omar, that wouldn't be
Yeah, the
applicable.
the child is now 3.
Okay, well, with the other child,
There were instances with the other two children.
there were 2 instances with the child. One when the child was 4 months old, the other time when the child was 5 months old. What the child had on, and it's not clear of where it was on the child's body, but the child had on a loose-fitting fleece comforter of some sort. It was a blanket. And does that constitute an unsafe sleep practice? What happened in this case, I think, is a failure of proof. We have these 2 caseworkers who say, we saw this, and we gave the mother a brochure.
It was one incident. There were multiple incidents, and each time it was mentioned and discussed. And, mom would say, I know what good sleeping habits are, and, I don't do the bad things. But
There were at least 2 incidents where that was observed. I agree.
But your argument, I guess, is that, so what if this was observed, that's not neglect, that there was no connection between wrapping a child in a blanket or loosely wrapping it and the conclusion that that's an unsafe sleep practice.
That is correct, Your Honor. I think the science in this area is very, very, very bad, frankly. Frankly, this is a case that almost cries out for a Fry hearing of what is the standard for unsafe sleep practices. I would also point out that the testimony in this case, particularly by Mr. Vadalaro, I believe his name is, in which he said, I gave her a brochure, and I don't want to talk about safe sleep practices. I know about safe sleep practices. They were talked about at DSS training. He doesn't mention what it is. And I'm a father. I have 2 children. Well, that doesn't prove a whole lot of what unsafe sleep practices are or actually what occurred. So I believe that the testimony in this case was significantly remiss. Now, there was also some testimony.
No, I agree. Let's move on to, the whole quantum of proof. What else?
There's other evidence of the mother having smoked marijuana. And there was evidence that she had smoked marijuana. But the standard under 1046A3, I believe, is that the person was not met in this case. And there's the Thomas case, the Thomas B case from 2016 by the 4th Department, which I believe addresses that issue.
Okay,
There were times where she smoked.
Yeah, so let's go to some of the stuff that's in the record. And not only just did she smoke marijuana, she smoked with her 17, 16, 18-year-old child. And it seemed that she smoked marijuana and then didn't take care of the children. I mean, I think that's what they were trying to say. That the children weren't cared for and didn't have enough of what they needed because mom was instead getting high.
Well, Your Honor, it's not that they weren't, I don't believe that there was evidence that they weren't being cared for. There was testimony that she smoked with her 19-year-old child. The child is actually 22 years old now, Abraham. I don't think there's anything improper of the 2 of them going out to smoke, including marijuana, outside the house, which is, there was evidence of that.
Well, wasn't there also proof that the 3, almost 4-year-old child was able to describe a blunt, how you roll a blunt, light it up, spark it up, get the party started? That seems to indicate maybe it wasn't just outside the house.
Okay, perhaps you may be right, Your Honor, but was there testimony that showed that she was unable to take care of the children, which is the standard under 1046A3? She smoked marijuana. She had a blunt on Halloween evening. I think most parents would like to toke up a blunt at the end of Halloween evening.
Tested on November 7th or whatever day.
She wasn't tested. She did not show up for that. The court made an adverse inference, but I don't think that adverse inference allows you to jump to a conclusion of marijuana neglect.
So what's interesting on this point is that the court dismissed the petition to the extent that it alleged that the mother was not supplying the children with adequate food, shelter, clothing, that sort of thing. So that seems to support your point on the marijuana use.
Yes, thank you.
Can I ask you one last question on that? I thought in your brief you discussed the Marijuana Regulation and Tax Act.
Yes.
And its retroactivity here.
Yes.
You believe it is it came down, I think, a day or two before the hearing or before the court's ruling. What effect does that have, if any, on our analysis?
Your Honor, what I ask is, and there's case law, and I should note that in the intervening period since I filed the brief, there's case law going back and forth on the appropriate retroactivity of an ameliorative, I think it is, statute that has been enacted. Now, almost all of those cases, as I recall, have to do with criminal law application rather than in a family law context. All of those cases may be distinguishable, both ones that are pro and con. But should this be, this finding be applied in this situation, or should she have the benefit of the ameliorative statute?
You're saying it's remedial, therefore, it should be given retroactive effect.
That is correct,
In
Your Honor.
this case.
Yes. And I don't have, as best I know, there's no case law in the family law area that is even directly on point, but there are cases going back and forth in largely, I believe, the criminal law area. If there are no further questions, I'll submit on my further points.
Thank you.
Thank you.
Good afternoon, may it please the court. Amanda Oren for the Monroe County Department of Human Services. We would submit that the family court's determination of neglect is supported by competent and compelling evidence in this case, and that this court, the court had a sound basis, was entitled to great deference for her decision, Judge Reed in family court. I think the problem with appellant's arguments is that he wants to look at things, or she wants to look at things in a vacuum. And really what this court, I would argue, and what the lower court did was look at the totality of circumstances before them. There was no evidence put on by appellant other than, at all in this case. Therefore, the judge took a negative inference against her, which she should have done and had every right to do. The only evidence that this court heard was from the Monroe County caseworkers, as well as the documentary evidence that was submitted, which show that mom had a long history of daily marijuana use. So much so that her older child, Gina, said, I can't tell the difference even between when she's high and when she's not. She uses so much. It's so prolonged. It's so extensive.
Was there a grandmother in the household?
There is a grandmother in the household, and there was actually, and the kids did not reference her caring for them, and there was no evidence put on by appellant either that that there were times that grandmother cared for the children when she was smoking marijuana or using marijuana with her oldest child.
But you agree, of course, that the use alone isn't enough to establish neglect. And what catches my attention on this case, I don't disagree that there's lots of proof of her use, or perhaps daily use, but what caught my attention is that the court dismissed the petition to the extent that it found that that alleged that the minimum care in terms of supplying the children with food, clothing, and shelter was not met. So, you have to show that her use, her marijuana use, created harm to the children or imminent danger to the children.
Correct.
Yeah.
Correct. Sorry, I didn't mean to interrupt you.
No, that's okay. Go ahead.
Yeah, correct. So I think the judge found it was more of an inadequate guardianship, which is why what the marijuana use, as well as just her bad choices, it shows a substantial impairment of her judgment, which is the neglect.
What harm was caused?
Well, she put her child, well, one, the safe sleep issues, right? The safe sleep issues.
What we're talking about as a result of the marijuana.
Well,
But you're arguing the totality.
Correct. The marijuana goes to, with the other issues, with the safe sleep, it goes to show that her judgment was impaired. And that caused her to make bad choices, which is,
Including the bad sleeping habits.
Correct. I continually, even though my child 2 years before died with a comforter over its face, my even younger baby now, I'm going to continually wrap in blankets. I've been told not to. I've been told that it's unsafe for this child to do that. I acknowledge that. I continue to do that. Moreover, they didn't have adequate bedding in the house. CPS said, we can help you get that. We'll make a Hope Initiatives referral. She didn't follow through. She didn't follow through.
They brought her a pack and play one day.
Right, CPS initially brought her a pack and play and said, we'll make a Hope Initiatives referral for further bedding. So you have enough beds in this home for everyone sleeping here. She wouldn't follow through. She didn't follow through.
There was
Moreover,
a date where she had no heat, and they tried to get her safe housing, and they did, and she didn't use it.
exactly. She said she would go and she didn't. And instead, they said, well, how are you going to keep your children warm? And she said, I'll wrap them in big blankets.
So I suppose your argument is that I think your opponent's argument is, do we automatically connect those facts to her marijuana use?
Correct, and I think we can. I think she didn't, that the appellant didn't testify differently. The judge took an adverse inference against her. I think this court can make that inference. Daily prolonged use of marijuana, even though now legal, I know that, doesn't mean you're not impaired. It's just like alcohol. You can be an alcoholic and live in the home with your children, but still make bad choices about what you do for them and how you care for them. And I would submit that's what happened in this case.
And for the failure to allow testing on a regular basis. I mean, the mother didn't allow, herself to be tested, top screen.
Correct.
On many occasions.
On many occasions, correct.
Okay, thank you.
Good afternoon. May it please the court. Mary Beth Barnett, the attorney for the children here. Gina is 16 now, living with her mom. The two boys are in foster care. Nasir is 14, Juan is 11, and they are, according to their foster mothers, have quite a few difficulties. That is, Nasir's foster mother indicated that he came to the home 8th grade, not able to read. He has behavioral issues. The 11-year-old also has behavioral issues. He's in foster care. He was, every day he was sent home from an aftercare program for, according to the foster mother, for a period of time. I'm simply presenting this is information on the record.
What about Jamar, the young one? Where is he? Where is Jamar? Isn't the one that was?
Jamar, okay, Jamar and Amelia are both with their fathers. And they are 4 and 3.
Okay.
And so, just respectfully, I guess I kind of see this case a little different than it seems it's been argued. I think the most important thing really in the beginning is to indicate whether or not the Family Court Statute 1046A3 can be applied retroactively, because that sets the whole standard for how the rest of the case is viewed. And I don't understand how the Department of Social Services could be expected to put on a case that was actually going to be determined by a statute that wasn't even in place at the time they put it on their case. So.
And I don't get how making marijuana legal makes it any less harmful.
Right, I mean.
If we were to accept the argument that was just made, that it caused impairment, that impairment then caused bad decision-making, would it matter that it's legal to use it if, in fact, it impairs your judgment and you make bad decisions?
Well.
I mean, alcohol is legal, and if you drink that regularly and it impairs you and you make bad decisions.
Right, if alcohol is used on a daily basis, like in this case, I think it's pretty clear the mother used on a daily basis, that was corroborated by the mother, by the children. And her impairment, the mother's impairment, I think that is what needs to be shown, not the children's impairment. And the daily use of marijuana, it can be inferred that there is a significant impairment. Plus, she had a lot of bad decision-making, like her refusal to take the tests, not coming home, no furniture, not taking the kids when it was cold to a safe place. All of these things show a poor judgment and not wanting outside people in looking in. So, from my point of view, the statute should rightly be applied retroactively, and that means that she needed to, and there was enough evidence on the record to force her to come back. There was a presumption of neglect, and she needed to put on a case, and she didn't. And all of this evidence from outside that's being presented here today was
When you say there's a
not
presumption of
presented to.
neglect, that's based on the adverse inference?
Right. And as far as the neglect of Jamar, for which was seen under, she did find under a different statute that did require that he was in imminent danger, it really seems clear that Department of Social Services bent over backwards to try to keep, try to inform mother, try to let her parent these kids. And she just simply refused to follow what they indicated, and it wouldn't have been, shouldn't have been that hard to do what was being asked. And, you know, this question of loose blankets and beds, and then obviously there were people changing beds. There were different adults in beds at different times. And it just is not the happy co-bedding that you see in, you can imagine happens among some families. So unless there's some questions, I just rest on my brief.
I just want to know what your position is with each of these kids. Should we affirm? I'm not sure.
Well, my position is that the lower court should be affirmed. I'm sorry I didn't make that clear.
Okay, thank you. 734, Riley versus Kidney.
Good afternoon, Your Honors. Cleo Weiss on behalf of Ebony Riley. There's not a sound and substantial basis in the record for this custody modification decision, and that's because family court entirely ignored the existence of an order of protection that was granted in favor of the mother in the time between the prior order, a consent order on custody, and the modification petitions that were filed by each of the parents in this case. And Domestic Relations Law 240 requires that when there's domestic violence, a court must consider the effect of such violence as part of its best interest analysis. And here, in the mother's modification petition, she makes allegations of domestic violence, writing, "Joshua is domestically violent." This is on page 22 and 23 of the record. And she also includes information about the order of protection in her petition. By the time we get to the fact-finding hearing, both parents acknowledge that an order of protection was issued against the father in 2019 and that it lapsed in 2020. And I think without any further information, in my brief, I say that family court abused its discretion in not ordering a 1034 investigation.
Did anybody ask for that?
Nobody asked for a 1034 investigation, but I think that without any additional information, a decision going from joint custody to the parents to granting this father sole custody and primary placement of the child is without a sound and substantial basis because...
But, counsel, that didn't happen in a vacuum. There was a hearing, there was, testimony, wasn't there? I mean, it wasn't like it just happened. There was, in between those two things, joint custody to sole custody, there was actually a hearing.
Yes, Your Honor, there was a hearing. I think it was a brief hearing. It was only the testimony of the two parents. And I think for family court to make this decision and grant sole custody to the father without knowing why was an order of protection issued, without knowing any of the underlying facts, family court could have taken judicial notice of those proceedings, which were before a different judge in family court. There were options family court had, and I think that without having any information in this record, we cannot say that there's a sound substantial basis to grant sole custody to somebody against whom an order of protection was issued.
Why don't we talk about some of the evidence that's in the record? And I think some of it has to do with the collaboration between parents. They were supposed to have joint custody, okay? But the mother, pretty clearly never collaborated with father about any issues. Unless you could tell me that there was any evidence of that, I didn't see any.
So I think there was two issues that were highlighted. One was the change in school districts, and the mother admitted that she did not consult with the father on that. But I want to go back and point out that that is during the time when this order of protection is in effect, and the mother testifies that she does not feel safe talking to the father at that time. So yes, she acknowledged that she made that decision when she moved after her grandfather died and she inherited his home and moved into that home. The child switched school district to be in Rochester City Schools. She acknowledged that was a decision made unilaterally.
Okay, and then there was more, right? I mean, she applied to all these private schools on behalf of this child without even telling the father about it. I mean, and there's a way to do it a little safer than a face-to-face conversation these days anyway. I mean, we're all amazingly attached to our telephones, you know, email, text messages, etc. I mean, but there was none of that going back and forth, right?
That is true, Justice Bannister, and I would point out that making applications to schools is not the same as switching a child's school. And the mother was extremely...
But that already happened once, okay? So now she's trying to do it again.
She's proactive about her child's education. The child was an A student at the time in RCSD. She pursues the best schools. The child was in Harley School, a private school in Brighton, was in summer enrichment programs. She's extremely proactive about making sure that her child is going to excel academically. And so, yes, she was putting in these applications, but I don't know, she did do one switch without consulting the father, but I don't know that you can make an inference that there was going to be another switch without that consultation.
Well, there actually was going to be a switch because the mother made all these applications. She was looking to make the switch. Now, right, maybe down the road it would have happened without consultation with the father, but mother freely admits she does not collaborate about anything with him. She said that on the record. We don't talk, you know, so that made joint custody really difficult.
I think
untenable.
What I would just say is that I would ask your honors to look at that in the context that there has been an order of protection and that there's clearly, the mother also testified that she's been diagnosed with PTSD as a result of whatever happened between her and the father. So I think in this context, that lack of communication, though it is the mother not communicating in these instances, your honor has pointed out, why is there no communication? And it may have to do with the father's past behavior and his violence, is what I would ask your honors to look at.
All right.
With that.
Anything further?
Your Honor, I would just ask that this court reverse this order and at a minimum remit to reopen the hearing and to have more hearings and to learn about what happened with this order of protection. I believe that family court needs to know that information in order to decide which parent is the safe parent for this child to live with.
Thank you.
Thank you.
Good afternoon. May it please the court. My name is Ted Baracco and I represent the respondent Joshua Kidney. I think that the record in this case is fairly clear that the evidence that was presented, given the opportunity to present evidence at a hearing by the appellant and the respondent, gave sufficient and ample support for this court to make the decision that it did, that there had been a change in circumstances, that joint custody was inappropriate, and that the father was the more fit parent. And I think that the petitioner's own testimony is what showed that she was not the more fit parent by denying visitation for long periods of time without, seeking court permission to do so, by calling the police on her daughter when her daughter wouldn't behave, by sending her daughter to a mental institution when she wouldn't behave. Clearly, she says that she had a strained relationship with her daughter and was not really able to take care of her. She did use her daughter inappropriately to babysit her younger son, and indicated that there would be consequences if she didn't do a good enough job. The father, on the other hand, is a nurse with a stable background. He has a situation where he has a variable schedule. His girlfriend is available to take care of the child as well as he does. He indicated that he does not have these behavioral problems with his daughter that the mother has.
What about the issue that counsel relied upon with the history of domestic violence?
Well, with regard to that, they refer to the history being the mother saying in her petition there has been domestic violence. I mean, she doesn't say what, she doesn't say when, and she doesn't say what were the circumstances. She didn't offer the order of protection into evidence. She didn't offer to present any evidence as to what occurred behind the order of protection, how the order of protection came into effect,
The
or
order of
series.
protection elapsed at some point. Did it elapse before the hearing commenced?
Yes, because I believe it lapsed in 2020, and our hearing was in April of 2021, I believe. So it had already lapsed. But this idea that a court, when hearing that, hey, there was an order of protection at some point in the past, has to put the brakes on to a case and say, I'm not going to hear your case, or I'm going to reopen your case because I heard that there was an order of protection, and I need to know what that was all about before I can make a decision here, particularly since the petitioner, or the appellant was in a position to bring that up during trial, and she did not. So the idea that, you know, I've lost the case, but it's the judge's fault for not independently investigating the history of Dad. And I don't know that that has any basis in the law. It's pretty unusual. And in any event, I believe that there is a substantial basis for this court's decision granting the father sole custody and primary residency of this child in the best interest of the child. So unless you have further questions, I will rely on my brief.
Thank you.
Thank you.
May it please the court, Mary Beth Barnett. I am.
The child is now 13? Is that correct?
My understanding is she's 12.
12, okay.
But sometimes I do that wrong, figure it out wrong. But I have spoken with her, and she is, I think, well-placed, feels she's well-placed in with living with her father. Her mother didn't take her from Brighton. Her mother took her from Brighton to the Rochester City School District. And now she's back in Brighton. My position is that the lower court should be affirmed. And mother simply just failed to present a case. She's just clutching at straws here. It would open a Pandora's box to expect the judges to tease out every case. She never substantiated any of her allegations of domestic violence. I agree with the respondent's attorney on that. She couldn't be specific, and I looked very closely to try to understand what was going on. I didn't see anything that had any tooth. She may have.
And the mother never, the issue, of course, is not preserved. The mother never asked for a child protective investigation.
She didn't ask for that, nor did she ask for a mental health evaluation, which might have been able to present more fully her own case that she had problems because of the dad. So it just seems as a case of somebody blaming another person for their own issues. So as again I said, unless there's any other questions, I'd rest on my brief.
Thank you.
Thank you.